ফোন কৰিছিল তেখেতৰো মেটাৰ বিলাক আছেতো so he says at a fixed time হলে better হয় so it may be taken out 3 তো দুটাত আমি অৰুণাচলৰ মেটাৰটো লৈ ল'ব পাৰিম তাৰপিছত যিখিনি যদি হয় ইয়াতে ল'ম তাৰপিছত তিনিটাত ৰাইজ কৰি দিম Yes.
May I please as a lordship? My lord, I beg to mention hearing item 36, 37 and 38 below.
36, 37, 38.
38, my lord, I have taken consent from the other council from the other parties, my lord, and a short accommodation we are praying because, my lord, this is a 21 matter. And current status I am waiting, my lord. What is the, I have challenged the proceeding of the learned trial court below me. It had been stayed. Now perhaps there is a development there, my lord, matrimonial disputes. So, my lord, maybe fixed after 3 weeks, my lord.
After 3 weeks. At the consent of the other side, the learned advocate, Mr. A.R. Bhuyan, paid for an adjournment, so and so will be released after 3 weeks. As on a date to be fixed by the registry. Other way also, today actually what had happened, my 2 benches are there, one from Arunachal at 2,
Well,
and then 3 and with Justice Surana and other
My
benches
lord,
there, division there. So it may be also in that may also
Yes,
it may
yes.
be taken up.
well, highly obliged.
Okay.
Highly obliged.
Okay.
May it please the lordship. Lordship, I beg to mention with regard to item 13, here additional
One-
affidavit has been filed.
1, 3.
With additional affidavit has been filed, lordship, that may be called.
Just a second, one thing, Ms. Song. Additional affidavit you are going to file in regards to
No, already-
ground of arrest.
Here, already filed, lordship.
Already filed, ground
Already
of,
filed.
just a second, ground of arrest you are taking? Ground
Yes,
of
sir.
arrest,
Along with others, along with others.
along with what kind of? Money, if you
Not other-
basically you are placing in
Basically,
the,
that violation of 50, 47, this.
that's what I'm saying,
No,
we are,
50. 47.
all matters we have been listing after, say, either 6th, 7th, 8th, we are fixing in that manner, because one issue is there, most probably we are not there. Some, the objection was raised by the learned additional PP, Mr. Koshi. So he paid for some time for his matters. So on 30th, yes, tomorrow matters will be heard, some matters, and the second, around 19 matters will be heard in that regard. So that's why all the matters which are related to grounds of arrest, we are deferring. That's why.
Let my matter come, lordship.
Okay, then.
Let my matter come.
Your affidavit is there.
Yes, lordship.
You have already filed.
Yes.
Okay, we are calling for the affidavit.
Yes.
May I please? Your lordship? I beg to mention item number 32 of today's list, my lord.
32.
On last occasion, case diary was called for.
Are you on interim there?
Yes, I'm on interim.
32. Issue reminder, interim be extended till new state of listing, when it can be listed to submit. 19th of May.
Interim order.
Yes, interim be continued till next state of listing.
May I please your lordship? I beg to mention item number 34. The anticipatory bail application.
Huh.
We are not in interim, but the case diary has not been received, lordship. The NDPS. Short date may be given.
From where it has to come?
Walpara.
Walpara.
Lordship. 15th of May.
1-5 will do.
Then 13, lordship.
Okay, on 13th. 13th করে দিব, interim 9 কিন্তু ইয়াতে issue reminder করে দিব 13th.
DPF.
May I please your lordship? I beg to mention item number 39.
30.
Yes, my lord. Case diary has not been received, my lord. We are on interim, my lord.
You are on interim.
Yes, ma'am. Any date, ma'am?
19th of
This one Dibrugarh.
CDB issue reminder. Interim be extended till next date of listing 19th May. Oh,
May it please your lordship?
Yes.
Your lordship, I beg to mention this bail application. And the point involved is the grounds of arrest, but your lordship has just indicated that all the matters will be taken on 7th. So
no, all the matters, no, we are fixing most of the matters on 5, 6, 7.
that's 6.
Your matters may be on 8 or 9. That's what I'm saying.
Your
Because
lordship,
9 out 8.
7.
7th, I cannot say 7th. It is almost. Okay.
It was
Okay, then she's saying yes, it can be. Which item number?
for mentioning, your lordship, it is not there in the list.
Because in the meantime, I have received the certified copies of the notice and.
For mentioning,
Yes,
okay, online, sorry, on
Seventh.
7th, okay, 7th.
obliged.
My pleasure, Lordship. I'm paying for listing on Friday, Lordship. Second, my Lordship.
Friday,
I don't know,
Friday,
Friday.
okay, okay,
May I please, Lordship? So I beg to mention item 15, my lord.
1/5.
1/5, my lord. This matter may be come up after 1 week, my lord.
It was bail hearing column or motion column,
Bail here.
bail hearing. You are not, you're on 15, 1/5.
Yes.
Yes, what is the position? You have received the case there. Are you on interim there? No. So we have received the case there. We are going to return the case diary. Yes, Goswami, when it can be. It has to be either 13, 14, 15. We don't have another dates. 15/5. We are listing it on 15/5. So 15/5 corridor at the request made by so and so. See the receipt. Retain the case diary till next test of listing. 15/5.
May I please, your lordship? I beg to mention item number 10.
But he is not in interim. No? Yes.
I beg to mention item number 10. We require some time to file our objection in this case.
Mr. Chaudhary is informed.
Mujumdar, IS Mujumdar, my lordship, this item pertains to a matter registered on July 2024, and a long time has already been passed actually. The accused is still in jail. So I could pray to this court that time may be given and a short duration may be also be given, and a direction may also be given that positively they filed an objection on that date.
Actually, the problem is, lordship, the IO is on leave. His father has some medical issues, so he will be signing the affidavit. That's why we are having problem to file this affidavit. So 2 weeks may be required, lordship, in this case. Earlier also, he was granted interim bail, lordship.
Lordship, in this matter.
Earlier also interim, you are still on interim.
No, I'm in jail.
Earlier.
My father expired, so there was an interim bail
Okay.
for the purposing of the Shraddh, which I went there and came back. Now I'm in jail.
Okay.
The thing is that I have been 325 days behind the jail, of which 321 pertains to I'm at Guwahati jail, and 4 days I was in Agartala jail. So it is taking a toll in my health of my client actually. So I could pray to this court that a short date may be given and a direction that positive.
Suppose your IO is not available or whether there is any other in charge, because if it is already ready, otherwise I'm not saying.
Lordship.
You can see in that way. Otherwise we are giving you need 2 weeks time.
2 weeks.
2 weeks কেটে থেকে হলো 2 will be okay for you 2
As per your court orders.
No, if we should, I mean, if he is going to, I mean, the IO may not join also, but you see, if suppose in any condition IO did not join, I mean, has not joined this so and so, in that case, so that you can file the objection by through any other ones. Yes. You are Mr. Jain, no?
IS Mujumdar.
Heard Mr. I.S. Mujumdar, the learned counsel for the petitioner, and also heard Mr. T. Jain, the learned counsel appearing on behalf of standing counsel NCB. Accordingly, he submitted that he needs some more time to file the written objection. Post of Mr. Mujumdar submitted in this regard that the petitioner is in jail for since last 325 days, and accordingly, he submitted that there may be a short accommodation. They submitted that a short date may be given to that effect. Next part, considering so and so corridor, submission made by land council for both sides. Let the matter be listed on 22/05/2025. However, the respondent NCB is hereby directed to file their written objection on or before the next date of list, positively on or before the next date of listing, if any. Okay, we are listing it on 22/05.
Obliged.
Lordship, another prayer with respect to item number 16, lordship. I requires 2 weeks time to file our objection. I have taken the consent from the other side.
Item number 16.
16, lordship.
You have taken consent of the other side.
Date may be fixed, lordship. He's behind
Same
the
order,
unpaid
hobo.
deed.
Same order will be there
Lordship, I am appearing for custom in this case, lordship.
for customs.
Customs.
Standing council customs here to hobo, to change over Khali. And Mr.
Amen, lordship.
Amen. Mr. A Mena, hard koi dibo, otherwise same hobo. Yes, here,
We require some time to file our objection.
no, it's okay. How many weeks you need?
2 weeks, Lordship.
Here also 2 weeks.
2 weeks, Lordship.
Okay, then in that case, we are fixing it on 2205.
Lordship.
2205, same order hobo. Kali naam bila change hobo, advocate sir, and he is representing Standing Council Customs.
Lordship on 14 or 15 Lordship.
Can it be possible, 14 or 15? 15? Okay, 15.
Much obliged.
My lord, I beg to mention item number 40, my lord. My name is
40.
40. My
Ah.
name is not shown, my lord. This may be taken after 2 weeks.
40, yeah, for the petitioner or the respondent?
My name is not shown.
No, that is the ground for your, what is you're saying?
This may be taken after 2 weeks.
No, you're praying for adjournment then.
Adjournment.
So have you informed the other side?
My lord, no, I shall inform, my lord.
I shall know, you should inform. You
now-
just inform and just let us know. I just point it here. Item number 40, na?
May I please, Lordship, I beg to mention for listing your Lordship, bail application 539/2025. This matter was last listed on 9/4/2025, but it was left over, your Lordship. And not listed since.
Maybe Thursday? Thursday. It will be listed.
Obliged, your Lordship.
My please, Lordship, I beg to mention item number 12 and 45. In both the cases, record was called for scan copy. I say will go.
12 and 45.
Lordship, I have some very unavoidable circumstance that I may be appear at 12, Lordship. Let the matter be called 12 first. Because Lordship will not be
will-
available after.
It is otherwise in motion column, na? Oh no, hearing column.
Hearing.
You want to get it on and by 2, both 12 and 45.
Yes, Lordship. If
Both the
Lordship will
matters.
be available at 2, because. Lordship-
At 2,
at-
you're
at
saying
2,
at 12.
At 12, Lordship.
Oh, yes, at 12, I'm here.
Okay.
That's
Deeply obliged.
For withdrawal item 42.
May I please, your lordship? I want to withdraw with liberty.
Your good name is reflected here. What's your name?
F. Khatun appearing on behalf of A. Mandal.
MSF Khatun appearing on behalf of
A. Mandal.
AA Mandal. AA Mandal. Wants to withdraw Koridigo. Dispose of on withdrawal. Okay, it will be disposed of on withdrawal.
We release item 1. Yes, your Lordship. This bail application has been filed on the strength of non-mentioning of the grounds of Edes Lordship.
Your one matter is fixed on tomorrow, I think.
Yes, Lordship.
Have you prepared the objection there?
Yes, sir. I have received the objection yesterday only. I am preparing on it, Lordship.
Okay.
And Lordship, the matter, in this matter, Lordship, the co-accused bail application is fixed on 9th of May,
Co-accused.
this court itself. The same may be fixed on the 9th of May.
Okay, then we are fixing it on 9th of May.
9th of-
In the meantime, if you file tomorrow any objection against the objection of the reply, if you, or you can verbally reply also, it doesn't matter. We'll record everything. So now date matter will definitely we are fixing it on 9th of May. Okay. 9 February, list on 9 February.
Highly on.
Okay.
Item 2.
My lord, this case also relates to non-furnishing of the ground of arrest. In the meantime, your lordship may be pleased to call for the scan of the scan copy of the LCR. And my lord, the other case, my lord, which is also on the same ground is fixed on 8. So lordship may fix this matter on 8. In the meantime, the scan copy will come. My lord.
No, but this is where we have not called for, oh, in other matters.
Yes. my lord.
Other matters scan copy is already called for.
Yes. yes.
Okay, okay. Okay, then we're fixing it on 8.
Yes. And the my lord,
List on 8.
special NDPS case 108/24 from Sri Bhumi, my lord. Scan copy.
Scan copy of special NDPS
NDPS case 108/24.
108 of 2024.
Yes.
Scan copy of the case record along with the CDB call for.
My lord,
Okay.
From Sri Bhumi, my lord.
Sri.
And on 8, my lord.
Yeah, we're fixing it on
My
8.
lord. Oblige me.
Item 3.
Yes.
my lord, here also, my lord, I've taken the same plea, that 47, and along with that plea, my lord, the co-accused has been granted bail. But for the 47, 48 plea also I have taken, my lord. Co-accused has been granted bail. That order I have annexed, my lord.
Now you know also that we are
Lordship,
releasing
not-
the
not- that's
prisoner.
why I'm
Now
not
that
pressing.
issue was raised, so that's why I thought
Lordship,
that
I'm not
at least
pressing,
one
my lord.
hearing should be there.
Lordship.
That's why.
Lordship.
So, but your matters, we have to fix it on not on 8 and 9 because already most of the matters are there. Can it be on 9? Yeah, somehow.
Not, my lord. Not really about you. Because co-accused has been granted bail, my lord, so my lord, they don't understand this. They think that, my lord, not a like coming on that is the problem, my lord. So, 9,
Matters.
8, my lord, 8, 7, 8,
1980 what?
7, 8 months.
I actually raised it to do something. No? Is that real?
My 7th or 8th, my lord.
Let us justice. 8.
Okay. Oblige your lordship.
List on 8 also call for this scan copy of the LCR along with the case.
Not LCM, the CD.
It's a CD.
CD.
Oh, just care for this CD. Okay.
The scan copy, no, case diary, my lord, he will put.
CD.
CD, only the.
Yes, yes, case diary, only
Lordship.
case diary, case diary.
Oblige.
Item 4.
We are also same ground, Lordship, and Lordship has fixed one of my matter on second. So can it be taken up second because our argument will be same.
It will be same, but second most probably yesterday also I just inform you, yesterday, second.
Because my
6,
other
5, it
argument,
can
I
be.
will cover this case also.
No, that is okay,
No.
but the question, we have to dictate the questions and then we have to deal, so it will take time. Otherwise, she's saying the 6th may be one of the matter, 6th. Second, we'll definitely hear your argument, that will be some outcome. On 6th, I'm listing it up.
Problem.
Item 5.
Yes. Yes.
Arrested on Lordship 1-4, Lordship. Today's matter 29 days.
Arrested on 1,
4, Lordship.
1, 4.
29 days, Lordship. FIR preset, Lordship 10, Lordship.
Under section 132, 121, 2.
Lordship.
What is this? What are these sections? Section. We have annexed the FIR here. It's a long FIR, no? Or what? Oh, no.
Page 10, Lordship.
Page 10.
Police personnel, Lordship, lodged the FIR, Lordship. Punishment, Lordship, less than 1 year. Extend to 10 years. Lordship.
Yes.
One 121 is earlier 353, I think. No?
Lordship.
May extend to 10 years. 121 2.
Yes.
29 days to go.
Yes. Short date, may be called for. Return by public servant.
Hatiga? Yes, when it can be called for?
13.
1-3. List 1-3. CD call for 1-3.
Item 6.
May I tell your lordship? Matter may be passed over after some time, your lordship. Messenger counsel is in another court. Oblige your lordship.
Second.
Wait, please, Lordship. The application for pre-arrest will.
Yes.
Lordship will find the FIR. May I take your Lordship to the vernacular matter?
Yes.
Page 14.
এজাহাৰকাৰীৰ বিনীত নিবেদন এই যে মোৰ ল'ৰা পাৰ্থপ্ৰতিম পাটোৱাৰীৰ বয়স প্ৰায় 10 বছৰ চেঁচামুখত থকা ট্ৰানজিশ্যন একাডেমীৰ ক্লাছ 4ত পঢ়ি আছে। যোৱা ইংৰাজী 22/8/2024 তাৰিখে মোৰ ল'ৰা উক্ত স্কুলৰ ক্লাছ কৰিবলৈ যাওঁতে মই একেখন স্কুলত ক্লাছ 3 পঢ়া ল'ৰা শহীদুল পিতা সোয়েঞ্চো, চিৰঞ্জীৱ কলিতা পিতা সোয়েঞ্চো আৰু সুমন দাস পিতা সোয়েঞ্চো ডাকৰ গাঁৱৰ চেঁচামুখত কাৰ চকত মোৰ ল'ৰাক মাৰধৰ কৰি ল'ৰাৰ সোঁহাতৰ গুৰুতৰ জখম কৰে। ঘটনাৰ বিষয়ে ট্ৰানজিশ্যন একাডেমীৰ কৰ্তৃপক্ষক উক্ত পদক্ষেপ অৱগত কৰাত তেওঁলোকে মোৰ ল'ৰাক চিকিৎসা সমস্ত খৰচ বহন কৰিবলৈ কৈ মোৰ ল'ৰাক চিকিৎসা কৰিবলৈ কয়। সেইমতে মই ল'ৰাক বাহিৰত নি চিকিৎসা কৰোঁ। প্ৰায় 2,80,000 টকা খৰচ হয়। ল'ৰাৰ চিকিৎসা কৰাৰ পিছত মই তেওঁলোকৰ পৰা চিকিৎসাৰ উক্ত খৰচখিনি বিচাৰি আছো যদিও কোনো ধৰণৰ গুৰুত্ব নিদিয়ে। Basically, my lord, the demand is for recovery of the amount that is expended. The FIR has been registered under section 117(2), voluntary harm. There's no voluntary harm.
Hard.
Hard.
Against whom?
Against the school authorities.
School authority, how can be hard?
Yes, that's
The hard by other person, yes.
Other two, but those are also bacha, na?
those are also there. And here the petitioners are the school authorities. Maybe. There's no allegation against them. Only the allegation is that they promised that they will take care of the amount.
So
of
1, 2,
expenditure.
3, who are they?
1, 2, 3, my lord.
Corona Kanto, Polida.
1 is the principal, my lord.
Acha.
2 is the secretary of the school, and 3 is the managing committee member. My lord. And 3, he is also a subject teacher, my lord, of a government school.
Heard Mr.
Because
B. Kaushik, the counsel for the petition, and also heard Mr. D.P. Goswami, the learned additional BP, appearing on behalf of state respondent. This is an application under section so-and-so in connection with so-and-so. It's better. Considering this submission made by learned counsel for both sides, I find it a fit case to extend the privilege of interim pre-arrest bail to all the petitioners till the receipt of the case diary. Okay, you will be under interim protection.
my lord, great.
When it can be fixed?
21 February.
Grateful, my lord.
Abide by some conditions will be there. Cooperate with the investigation.
Yes, sir. Lovely.
May please your lordships, 482 of Indian Penal Code, my lord.
Yes.
Earlier it was rejected. This is second time, so case diary may be confirmed.
Earlier
Up to date, yes, ma'am. Lordship has been rejected.
Heard MSKDB, the learned counsel for the petitioner. Also heard Mr. D.P. Goswami, so and so. This is the subsequent bail application. Accordingly, let the CDB updated case diary be called for. List accordingly when it can.
19 February.
19.
Which medical report?
Injury
Yes. 19 along with the medical report.
Hello, please. For bail hearing, item 11.
Lordship, in this case, Lordship, the accused in custody about 1 year, 5 months, Lordship. At Lordship, since at the time of arrest, Lordship, ground of arrest is nothing communicated to the accused person, petitioner and the family members, Lordship, and I have gone through the entire record, Lordship, in the scan copy. The ground section notice 50 is Lordship, there is nothing mentioned. And Lordship, arrest memo is nothing mentioned, and also the inspection memo, Lordship, there is nothing mentioned anything else, why he was arrested, Lordship. And Lordship, some contraband is recovered from their, not their exact possession, from the rented house, Lordship. So, my Lord, about 1 year, 5 months in custody, Lordship. But the ground of arrest is not communicated to the accused and his relative also, Lordship. So at this stage, my lord, my humble submission, lordship, he is a local person from Guwahati, lordship. You kindly enlarge the bail on, well, otherwise the Pihan Kumar case is very elaborately explained about the ground of arrest and it should be communicated to the, and the section article 22 and clause 1 lordship and also very clearly mandate provisions. Violation of these lordship. At this stage, lordship, the
Okay, then your matter is also, we are listing it on 14.5. Because we are deferring those matters, so we are listing it on 14.5. In the meantime, call for this kind of copy of the LCR along with the case diary. LCR already received. LCR has already been received. List on 14.5.
14.5
I said already, yes. 14.5, 1-4.
for order, lordship.
No, not for order. We'll
Very.
break up the matter.
Lordship. Lordship.
List on 14.5. Yes.
30. Item 30.
Dear Lordship, petitioner is entitled for default bail, Lordship. Today, on 1st of November, he has been arrested.
He was arrested on 1st of November.
November. And November 30 days, December 31, January 30, February 28 days, March 31, and April today 29. So to my calculation, it is 180. Apart from this, I have also taken the grounds of arrest.
It's only 180 days.
Yes.
November 30 days.
Yes.
December 31. Jan 31. February 28. March 31. $180 days is not completed, I think.
180 days. From first, he has been on the 31 arrest was made and forwarded on 1st November. So 1st November to 30 November, 30 days. And then 31, 28 February is 28. And then 31st March. And then 29.
Yes, 180 days. Yes.
The
180
escape
days.
may be called for, my lord. You have to produce the escape to my lord.
No, 180 days is already there. 180 days means it's a charge sheeted case, not charge sheeted. That's what he's saying. She's
No,
saying.
that we have to verify, my lord, whether search is submitted or not, my lord.
Then he has to take
Take
instruction.
instruction.
My lord, take instruction, my lord.
Let him take instruction.
Today only you can take it or tomorrow.
At 2, my lord.
At 2. Okay. But listen, we are listing some list numbers of matters because at 2 Arunachal matter is there and then maybe it may be over by 2:30.
2 minutes. Only.
At 2. Okay. 2 p.m.
I'm up.
14.
May I please have a- the case that he was called for, my lord.
The case there is not received, my lord. No, in fact, my lord, up to the city was called for, my lord. Earlier we received the case there, but today we have not received, my lord.
It's around 86 days in custody, my lord.
86 days.
86 days. And other co-accused persons who are directly named in the FIR, my lord. As per our instruction, my lord, and my lord, we have checked up, my lord. My lord, they were granted the bail, statutory bail, my lord. And the FIR states, my lord, they are dreaded, my lord, terrorists, my lord. But possibly, my lord, they did not file the charge sheet. So, my lord, that bail was granted to them by the learned, my lord, special.
Okay, this is under UAP Act.
Yes, ma'am.
So here, so otherwise 90 days, if any pair of extension, then it will be suppose 180 days or whatever. But the question is that, do you have any instruction in that regard?
That instruction we do not have, my lord, but earlier, my lord, when the case diary was received, my lord, it was stand for up to date, my lord, because the case diary was not up to date, my lord.
But today your petition is 86 days.
86 days, and if we have annexed the forwarding report of the main accused, our also the FIR, everything we have annexed, my lord. And my lord, no recovery from so far these accused are concerned, my lord. And so far, my lord, the other accused person where there are specific allegation against it, in fact, against them also no recovery. So far, this case is concerned. They might be having some other case, my lord, from there, some recoveries were made. So far, this case is concerned, my lord. my lord, here, my lord, the FIR, my lord, it was lodged, my lord, 10/12/24, specifically against, my lord, one Sadda Radhi and, my lord, around 9 persons, my lord, and thereafter, my lord, when the sections which were added also, my lord, subsequent to the lodging of the FIR, that was also, my lord, added prior to the arrest of the present accused petitioner, accused person. That means, my lord, those were against the other accused person. That is apparent, my lord. If your lordship kindly have a look at page, my lord, 18. Months, my lord. Their lordship's in involvement of accused Ghazi Rahman. Page 18, my lord. And thereafter, my lord, kindly have a look, my lord, at next page, my lord, page 19, my lord. There one Noor Islam Mondal is named, my lord. And he was found to be involved in a different case in West Bengal, my lord. And another person, my lord, that para 3, my lord, Abdul Jahir Sheikh, my lord. That is also a different case, my lord. And now page 20, my lord. That is also a different case against Ghazi Rahman. And those sections were added, my lord, prior to the arrest of the present accused petitioner, accused person, my lord, because it was added on, my lord.
25(1)(a) arms is added.
Yes, all these sections were added on 3/1/2025. And the present accused, my lord, he is in custody, my lord, from 3/2/2025, my lord. So prior to the arrest of the present accused person, my lord, these sections were added in relation to the involvement of the other accused person. Again, my lord, that initially it was under 13 and 14, my lord. I'm sorry, my lord. Some corrections were made, my lord, that lordship may not have a look, my lord. Now, my forwarding, lordship, kindly see page 23, my lord. February 2025. And my lord, page 24 is the involvement of the present accused person, my lord. Grounds of arrest, my lord, as per the forwarding report. So he was having direct link with one of the prime accused, Noor Islam Mondal. That is the allegation, my lord. And my lord, he is found to be involved in conspiracy to commit terrorist act. So this is the, my lord, forwarding of the present accused. And thereafter he was taken into police custody for 7 days. That lawsuit found at page 28, my lord. 7 days police custody. Thereafter he was reproduced. Kindly have a look at page 30, my lord. That he was thoroughly interrogated. Page 30. So no further police custody was sought, my lord. Page 30. Now, my lord, lordship may kindly have a look at the, my lord, forwarding report of the main accused persons, my lord, because there is no item of any reference so far this present accused is concerned, my lord. That lordship find page 35, my lord. Page 35, my lord. That is the forwarding of Noor Islam and all the other persons who are named in the FIR, my lord. Around 8 persons. And my lord, they are the grounds of arrest of those persons, my lord. And more particularly, my lord, that Noor Islam Mondal, because they state that I am having some relationship and connection with Noor Islam, my lord. That lordship, Noor Islam is number 1, my lord. And that I haven't found, my lord, that something has been stated against me, my lord, subject to correction by my Barnett PP, my lord. Additional PP, he has found something, my lord. So all this is regarding Noor Islam, my lord. Lordship would find, my lord, from page 38, para 5, then page 39, para 6.
My humble submission, my lord, let the matter be fixed on 2nd of May, my lord. We'll produce the case there, my lord. This is from FPF, my lord. This is from Guwahati only, my lord. So we'll produce the case diary on, my lord, there, my lord, on 2nd, my lord.
My lord, then
Second,
again,
my lord, 89 days, my lord. If he is, my lord, we cannot produce the case diary, my lord.
And what has,
Lordship may pass necessary adjournment. Because my lord, earlier we received the case diary in this case, my lord. We have returned the case diary because my lord, it was not up to date, my lord. So today it has again come, my lord, but unfortunately we have not received the case diary. So my humble submission, my lord, that the case diary will produce the case diary, my lord, on second. Lordship may fix it on second, my lord.
and what has been recovered from me, my lord? Kindly have a look, my lord. Page 41, my lord, that voter ID, PAN card, Aadhaar card. And he's a family man, my lord. We have annexed all documents starting from page 45, my lord.
Okay, list corridor, this is the considering submission of Mr. Borba, the land division keeping. List the matter on the second you are saying,
Second, my lord.
2/5/2025 for updated case diary. And I is hereby directed to furnish the same on or before the next date of listing without fee. In the meantime, you can also take instruction in regards whether any prayer was made.
My lord.
All other, my lord, those persons, my lord, there's the alleged so many things against them. No charge sheet, my lord. All out, my lord, on being. Much obliged. my lord.
Second. Updated case diary. Okay.
17.
You have not taken steps, no?
Yes, my lord.
You have not taken steps. Why?
I'm sorry,
It's
my
a
lord.
6 POXO, I think.
Yes, my lord. POXO
Then?
matter.
That to 6 POXO. Why you have not taken steps?
My lord, but today I will take the step, my lord.
Today only?
Yeah.
Heard Mr. A.M. Borgnia, the learned counsel for the petitioner. From the, and also heard Mr. R.J. Borg, the learned additional people, appearing on behalf of state respondent. From the office 2025/4/2025, it is seen that the scan copy and the is still awaited, and the petitioner has not taken any steps on the respondent number 2. In spite of specific direction on 28/3/2025. Accordingly, it is the petitioner is hereby directed to take immediate steps on respondent number 2 through jurisdictional police station, routed to the office of the registry and the public prosecutor. The registry is also hereby asked to issue a reminder to call for the scan copy of the case record. Yes, when it can be listed.
Any date, my lord.
It is a charge sheeted case
Absolutely.
after 2 weeks. List accordingly after 2 weeks. Okay.
Obliged.
18.
Here, I require some more time to file my objection. The 330 gram of heroin was seized from the one lady. And on his her disclosures, he was arrested in Agartala. After years, he brought here investigation on 25/1/25, he was arrested. I require 10 days time to produce the stage of investigation and materials collected against it.
Your lordship, since the date of filing and of today, it is already 1 month has elapsed, your lordship. Maybe one less amount of time to file the affidavit. Affidavit may be nevertheless be filed, your lordship. And the only allegation against us is that the chief accused who was arrested with the possession of the drugs, after 2 to 3 days have named that we have supplied the drugs. And thereafter we were arrested from Agartala and not from Guwahati railway station. And therefore, your lordship would like to take the affidavit in opposition before the final hearing. Already 60+ days behind the bars, your lordship. And so 1 month has elapsed since the filing of the case and calling of the case diary, your lordship.
But since the investigation is going on, Lordship, and IU has already gone to Tripura to make further investigation. And sufficient materials are there. He approached the land trial court, decision order was passed, after considering all the aspects of the matter.
Heard Mr. T. Laskar, the learned counsel for the petition. Also heard Mr. S.K. Kyle, the learned standing counsel NCB. And it is submitted by Mr. Kyle that he needs some more time to file the written objection as well as to produce the case diary along with the present status of the case. Considering the prayer allowed, the matter, you may need 10 days time.
10 days.
10 days, when it will be 10 days? 1/5. 1/5? Oh.
Much.
1/5. have queried and the NCB will accordingly produce the case diary and the objection, if any.
Lordship kindly pass over the matter for some time.
Here we
Material
have
is
received-
coming, he's busy on
We
another.
have received a case diary.
Case diary, okay.
Public.
Scan copy because I see.
Scan copy was received here. Just for time being. Yeah. Oh, he is here. Active, 21, 20. We received here the scan record.
Scan copy received, my lord.
And status report was also called.
Pardon?
Status report also called. 5 of 8 until 5.
So what is the position in the case?
Position, my lord, some witnesses examined, my lord, and they have implicated, my lord. 23 kgs of ganja recovered, my lord, from 2 persons, my lord. Akash Arya and Mukesh Paswan, my lord. Mukesh Paswan is the present petition, my lord.
So otherwise in your custody since when?
Since my lord, 14/12/2022, now 867 days. 2 years, 4 months, 15 days, my lord. And the co-accused who has been already released on bail 1 year back. Now, my lord, from my possession, from the High Court, this honorable court, my lord, case 107 is the order, my lord.
Who?
Honorable Justice Ajit Bhattacharya, my lord, is not there.
So at the stage, how many witnesses as per you?
Out of 8, my lord, 5 witnesses examined. 3 remains.
The trial sufficiently progressed, my lord. The question of wrong incarceration will not come, my lord.
Our the 13 kg 800 gram was recovered from my possession, and that is not a commercial quantity, although our charge has been framed under section 20C.
What was the quantity?
Ganja.
23 kg from 2 persons.
Yeah, rightly submitted that the 13 kg may not be the commercial quantity, but 29 is there, in fact. So when 29 is there, then definitely the conspiracy part is there. And you two were traveling on the same train?
Same bus.
Same bus.
Same bus, my lord. But my lord, he has been released on bail, my lord. Now, more witnesses are to be examined, my lord. It will take several years.
My lord, out of 8 witnesses, my lord, only 5 examined, my lord. And as on that, my lord, we do not know that is status report, my lord. So, my lord, it will not take much time, my lord. And my lord, if he is granted bail, my lord, he may, my lord, evade the further trial of the proceeding, my lord.
My lord, both the
Because he
accused,
may not come, my lord, after he is, my lord, released on bail, my lord.
my lord, both
Because the witnesses are implicated, my lord.
both the accused are from Bihar.
one has been released on bail.
No,
By
both
this
are not from
honorable
Bihar,
court,
my
my
lord.
lord.
Accused who was released on bail, my lord, he was from Manipur, my lord. That is reflected from the, my lord, order. My
Yes, yes, I'm sorry, my lord, the Manipur, but out of Assam, my lord, from another state, and I am from Bihar. My lord, in this regard, my lord, I would like to rely on judgment, my lord, one order of this court, my lord, on the prolonged incarceration, my lord. Bail has been granted by this court, my lord. Wherein, my lord, discuss so many case laws of honorable apex court. But I'll
Yes, please, please.
here, my lord, it was also involved commercial quantity, and the petitioner was behind the bar for 3 years, 3 months. And the law discussed, my lord, the honorable apex court in Siddha Viswas alias Shubha, my lord. He was in jail since 1 year, 6 months, my lord. Honorable Supreme Court has granted bail after 1.5 years, my lord. So, my lord, my detention, my lord, 2 years, 4 months. My lord, at any condition, my lord, may release him on bail. And there is no chance of, my lord, hampering or tampering, my lord. Only vital witnesses have been examined, my lord.
The question is that, my lord, it's a charge-debt case, my lord, so lordship will have to consider bail application on the basis of merit, my lord. Now, my lord, out of the 8 witnesses, 5 have already been examined, my lord. They have implicated both the accused person, my lord. Now, my lord, the recourse of 37 will become, my lord. If lordship allows his application, my lord, lordship will to satisfy the two condition, my lord.
Yes.
That after releasing on bail, my lord, he will not commit the offense again, my lord. So my humble submission, my lord, after, my lord, recording evidence of 5 witnesses, my lord. So there cannot be any question of, my lord, prolonged incarceration. Because during the, my lord, last 2 years, my lord, as my learned presence submitted, my lord, 5 witnesses are examined, my lord. And till that, my lord, maybe, my lord, some other witnesses also examined, my lord. That after the report, my lord, has on that not received, my lord. My humble submission, my lord, that the trial court proceed with the matter, my lord. And at least, my lord, the bail application may be rejected.
My lord, so far, section 37 is concerned, my lord. Just now I have supplied the copy. Herein discussed, my lord, in Muhammad Muslim alias Hussein versus State of Delhi, my lord, reported in 2023 SCC online, SC 352, my lord. Here, the Honorable Apex Court observed, my lord, grant of bail on the ground of undue delay in trial cannot be said to be fettered by section 37 of NDPS Act, my lord. So, I leave it to your lordship, my lord. Instant copy is there, my lord. Lordship will, my lord, consider my bail prayer, my lord. Since the other accused have been already on bail, my lord. Obliged, lord.
এটা কাম কৰিব এই ৰেকৰ্ড বুলি গৈ তুলি পাক নম্বৰ টাইপ পাতি লগত দি দিম ডিসপোজ
Twenty-one.
My lord, case that is not received to them.
so you are appealing for the response number 2
Video file.
none appears on call for the petitioner heard Mr. Ajibol, the learned edition PP appearing on behalf of state respondent and also heard MS. Yes. MS, your good name?
Embora.
MS Embora already have entered into appearance on behalf of the respondent number 2 and she submitted that Bakalatnama has been filed today. You have not received the scan copy. CD, na?
CD, my lord. Yes, sir.
However, CD not received, issue reminder. Let the matter be accordingly listed after
16.5, my lord.
16.5 you want, 16.5. Oh,
22.
My lord, the diary was false for my.
We received the case.
No, the regular bail application matters for 83 of the BNSS, my lord. Here, my lord. Mandatory period is 60 days, my lord, and he is in custody from 18-3, that is around 43 days. 43 days in custody, my lord. And my lord, case 15 is the FIR, my lord. Contents of it was a complaint, my lord, which was filed before the court, my lord, case 15, my lord. Regarding, my lord, discrepancies and, my lord, obtaining fake and fraudulent, my lord, that form 50, my lord. Now, although, my lord, there is one legal point here because, my lord, directly it was, my lord, complaint was made before that court, my lord, without exhausting the remedy before the police, my lord. There is 1-2 judgment on that count, my lord. I am not on that now, my lord, because already 43 days in custody. And here, my lord, they did not, my lord, resort to 35-3, my lord. That 41A, my lord, earlier, my lord, that was not complied with, my lord. And 43 days in custody. Possibly everything has been recovered, my lord, and further detention may not be required, my lord. And he got all these documents from a different person. He has named that person also, my lord. And in para 7 of our petition, we have named that person, my lord, from whom he got the documents, my lord.
From 50 was required for person taking a loan, lordship.
Yes, yes.
He was
Not only loan for selling and these things also,
lordship.
for sale of a land.
But he was and
Uh,
and he was handed over.
So it was, the FIR was filed by Chief Administrative Officer, District and Sessions Judge Kamrup.
From 50 was that was not issued. by
But
the-
your petitioner, who is he? He obtained the form 50.
He is an advocate clerk, my lord. And
Advocate
he
clerk.
got it
Oh,
from a
advocate's clerk.
he got it from a different man, my lord.
Yes, he received a Form 50 from Abdullah Ali. Yes, he was connected. Handed over to him that please provide the Form 50 to me. So he was given to Abdullah Ali to provide this Form 50 lordship.
One Abdullah Ali.
Abdullah Ali.
So the question is that on Form 50, our office has a liability to see all these, whether any case is pending,
No, I
whether
do
these
not.
things are there, certificate has to be there from our office. So they obtain the certificate from Form 15 or fill up by them.
Possibly fraudulent.
It was fraudulent. Form 50 is fraudulent. It was not
Fraudulent.
given issuing by the court lordship.
No, Form 50, that because it was filed by our office, na?
Lordship.
So I'm just asking that these petitioners, how he is involved in? He obtained the Form 50.
My lord,
Given the point to give it in court.
he was given by that Abdullah Ali, my lord. He
Ah.
procured it, my lord. He done it, my lord, and he submitted it before the court. That is the case, my lord.
This Asadul submitted.
Yes, sir. And it is a fact, my lord. Those are, my lord, fake, my lord. And fake, but not, we never knew it, my lord, because Abdullah Ali gave it to us, my lord. I also worked there, my lord.
Abdullah, how one strength he is
He is
there?
also an advocate, my lord.
Advocate's clerk.
Yes, yes, my lord.
This petitioner was taken to the responsibility of providing the Form 50 and
Yes.
he was handed over to another person, Abdullah Ali. He has provided to this petitioner the Form 50 and he has provided who was interested to take the Form 50 lordship. That is what not issued by the court, but it was fraudulent. That Form 50 was.
Yeah, not going to take the merit, my lord, 43 days, and that 41A, 35-3 of the BNSS not complied with, my lord. 5 days police custody, and all documents possibly seized, my lord.
Heard Mr. A. Chaudhary, the learned counsel for the petitioner, and also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application in section so and so in connection with so and so. He has diary received, is the same. It is submitted by Mr. Chaudhary that the present petitioner is in custody since last 43 days, including 5 days police remand. Further, he submitted that he obtained the he obtained the Form 50 only from one Abdullah, the co-accused, who had fraudulently entered some who fraudulently entered some data in the Form 50. Further, he submitted that police also got sufficient opportunity to interrogate him, keeping him in custody for last 43 days. And 43 days full stop. The accused petitioner is, however, still ready and willing to cooperate the IO in further investigation of this case. Mr. and Mr. Mr. Gusami, the learned additional PP, submitted in this regard that the case is sufficiently progressed and the some of the documents has already been collected. Further, he submitted that it is a fact that the present petitioner obtained the Form 50 from one Abdullah, the co-accused. Next part, considering this submission, so and so will be video. To whose satisfaction, this is CGM Kamrup.
Learned CGM Kamrup Amin Gaon.
CGM Amin Gaon. CGM Kamrup Amin Gaon. Okay, we'll continue.
Much obliged, highly obliged.
May it please your lordship. Lordship, this is a regular bail application, 32 days in jail custody, lordship. Here, anticipatory bail interim protection was granted one of the FIR name accused person. Lordship will find the FIR that is on page 16, lordship. It is the case, lordship, remember, lordship, to 4 drum of diesel, lordship, capacity 200. But what is actually recovered from this petition, that was not stated, lordship. That case, lordship, may remember. Otherwise, lordship case was registered under lordship 2 special act, that is 23A of the Petroleum Act, lordship, it's available, and 7 of the ECA Act, lordship, it is also available. Now, lordship, other IPC section, lordship, 362(2)B and 302 is 3032 is their lordship. 3032 lordship, in the first offense, it is the imprisonment extend up to 3 years, lordship. And subsequent, it is for lordship, extend up to 5 years, lordship. Now, considering lordship, already material has been recovered, lordship. One co-accused has been protected, provided interim protection, lordship. May I pray, lordship, this petitioner already in jail custody for 32 days. And moreover, lordship, no private complaint against this petitioner, lordship. So, lordship, 35(3), that notice, or 41A, lordship, that notice has to be complied with, lordship. That was not issued to this petitioner, lordship. Neither, lordship, anything stated in the forwarding report why they have not issued that notice, lordship, in the ground of arrest. That is not given, lordship. In the forwarding report, that is, lordship, will find on page 18, lordship. Otherwise, lordship, we have a landed property, lordship, tractor and 13 sets of diesel pump, lordship, installed in the field, lordship. That require, lordship, petrol for running that, operate that lordship pump to irrigate in the land, our land, lordship. Considering, lordship, length of detention already 32 days, lordship, 32 days today, lordship. On the last occasion, lordship, I placed that interim protection order that is probably in the record, lordship. One of the co-accused, lordship, Dulal Ali has granted, lordship. Otherwise, I have given the lordship pump set photographs. I have given, lordship, the tractor registration certificate that also, lordship, annexed with my petition, lordship. Only considering the length of detention, lordship, recovery already been made, lordship. That may handle some issue, lordship.
They are doing that 200 liters of diesel was recovered from them, lordship. And even their statement, from their statement, it reveals, lordship, they are doing it illegally, lordship. There is no, and they could not produce any receipt that they had purchased 200 liters is huge quantity. They have purchased it, lordship. And the neighbor also said that, lordship, they are doing this, lordship, business, lordship.
But case was,
apart from that, lordship, giving interim protection in another accused person, that is not the final, lordship. We do not know what is the outcome of that case, lordship.
Lordship, interestingly, lordship, case was registered under bailable section, lordship, 23(2), lordship.
Lordship, lordship, because of that, lordship, they could not produce it, lordship. That
Sorry, 23A, lordship.
Investigation is going on, lordship. So it will reveal, lordship, where from it is they have collected and anything keeping it illegally, lordship, that is it among theft, lordship. That is what it is.
Mr. B. Chaudhary, Iran and counsel for the petition. And also heard Mr. P.S. Longcourt, he learned additional PP, APM on behalf of state respondent. This is an application on section so and so in connection with so and so. Did he received? It is received. It is submitted by Mr. Chaudhary. The accused petitioner is in custody since last 32 days. And thus the IO got sufficient time for his custodial interrogation. Further, he submitted that till date there is no private complaint with regards to theft of any petroleum goods. More so, those petroleum, it is a fact that some amount of petroleum diesel were stored because for using those diesel only for his for the pump set, which pump set and the tractors which were installed for India cultivation land, cultivated land. Further, Mr. Chaudhary submitted that the Section 7 of the EC Act, as well as Section 23 small a of the Petroleum Act are also bailable offences, and there is no ingredients to attract the other sections registered under the BNS. Mr. Chaudhary further submitted that the petitioner is, however, still ready and willing to cooperate the IO in further investigation of this case. Next paragraph, Mr. Lockhart, the learned listening PP, submitted that there are sufficient incriminating materials so far collected by the IO, and they could not produce any receipt, money receipt, to prove that they had purchased the diesel for their to cultivate their land or to use in their tractors. Most of huge quantity of the diesel were stored in the house of the present petitioners, and accordingly, full stop. Mr. Lockhart further submitted that the case is still under investigation, and hence the petition may not be considered at this stage. Next paragraph. Considering the interest submission made by learned counsel for both sides, other materials in the case record, and also considering the length of detention already undergone by the accused petitioner, I find that further custodial detention interrogation may not be necessary in the interest of the investigation. Find it where to, it is a case of where?
CGM Nolbari.
CGM Nolbari.
Highly obliged.
My lord, nothing was recovered from the possession of these petitioners, my lord.
Respondent appeared.
Respondent?
Oh, issue notice. Oh, state is also there, na?
State is.
Okay.
Nothing
Yes.
was recovered from the possession of the petitioner, my lord. And my lord, there is an additional affidavit which I have filed, my lord. My lord will see both the arrest memo as well as section 47 BNS. I have the certified copies I have annexed, my lord. The original, and even the case diary is also here. Your lordship may cross verify in case your lordship intends to. Page number 22A of my additional affidavit running page, in fact 21. I will see the running page number 21. From 21, your lordship may see there are two petitioners, their arrest memo and their section 50 notice. Nothing is there, my lord.
Is also the direct recovery court-handed or any other?
No, it was recovered from the FIR is there. It was recovered from two other persons. My lord, I'll show you from the FIR itself, my lord. It is there in the FIR.
From their statement,
Section 67 statement.
So now what is the progress of the investigation?
Report notice is yet.
It is 104 days.
Well, FSL assuming that is contraband, assuming, even then, my lord, it is on the basis of 67 statement, no 164 statement. My lord may see from the FIR itself, page number 10, para number 3. it is recovered from one Onkojin, Thao Thang, and Thangha. My lord, this difficult on my part to pronounce.
So as per their statement, they were going to sell the contraband to these petitioners. They were apprehended, these petitioners.
No effort was even made to record any 164 statement, my lord. No police remand, nothing has been sought, my lord. They are in judicial custody and the arrest is vitiated from day one, my lord. Vitiated from day one.
And what is the other entries?
They have, yes, statement is here also.
I'm dealing with your case because it is not a case of court red-handed. That's why
No, it is
I'll
not.
pass the order.
This is not a case of red-handed. No.
Recovery was made from the other two persons, from their vehicle also. And from their statement, these petitioners were arrested also. That they were going to sell the contraband to these petitioners also.
Those are 67 statements, my lord. I need not make any further submission in view of Tufan Singh's case. My lord. And even your lordship has also in some of the judgment held that those are inadmissible evidence. I'll just indicate, my lord, the relevant part of the FIR, which says that it was recovered from somebody else. Page number 10, para number 3, my lord, message. My lord is there at page 10.
How many petitions are there?
Two.
Yes, in page 10.
Page 10, that is the FIR, para number 3. I'll only. At 7 a.m., the said vehicle were intercepted at Amingaon and two occupants, namely those two names which I have said, were found and quizzed. The vehicle was checked and found 96 showcase. It was found from that vehicle from the possession of these two persons. This is one. Second, my lord, kindly come to my bail petition, page number 14. This is the arrest memo of petitioner number 2. Arrest memo of petitioner number 2. Then your lordship may take up the additional affidavit, from page number 21 onwards. From page 21 onwards. Page 21 is the typed copy of the arrest memo of petitioner number 1. And the original copy is at page 22. And page 22A and 22 and 23 are the section 50. Sorry, these are the arrest memos. 23 and 24 are the section 47 notice. These are the section 47 notices. That's my case. I'm deeply aware. I'm deeply aware.
Oh. Other than how many days?
Otherwise, my lord, they are in custody for 100 and
As per my calculation, 104 days.
104 days. 1,400. 104 days.
No, I took PPL of my son. 104 days. 15,125.
Date of arrest 15/1/2025.
Okay.
I'm deeply obliged, man.
Twenty-five Lordship, we have received the case diary. Now, earlier the Lordship has gone through the case diary. There are Poca mysteries who are involving in selling the contraband for earning easy money. There are three perspectives are there. They are the Poca mysteries, and to earn easy money, they are selling drugs. And 51 days as on today.
How many?
51 days as on today, Lordship. FSL report not received yet.
Intermediate quantity and up to 250 gram is intermediate. They are 57 gram. Kindly custodial period may kindly allow your worship.
FSL is not yet.
FSL is not there.
Heard Mr. A.R. Karim, the learned counsel for the petitioner. And also heard Mr. P.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application in section so and so in connection with so and so. Updated case diary has already been received. However, it is submitted by Mr. Borwa that the FSL is yet to be obtained by the IF. In that context, Mr. Karim, the learned counsel for the petitioner, submitted that the accused petitioners are behind the bars since last 51 days, and hence, considering their length of detention, they may be released on bail. This is not a case of commercial quantity, and hence the rigor of section 37 will also not follow. And police got sufficient time for their custodial interrogation. However, both the petitioners are ready and willing to cooperate the IO in further investigation. Hearing the submission made by learned counsel for both sides, considering the progress of the investigation and in progress of the investigation, it is seen that no, considering the hearing the submission made by learned counsel for both sides, and also considering the fact that FSL is yet to be collected by the IO, I find that there may not be probability of filing the charge sheet within the statutory period. And hence, without going detail into the merit of the case, the bail prayer for the present petitioner is hereby considered on the period of detention already undergone by line 2 down. Okay, we will granted with bail. To whose satisfaction this?
A special judge.
Special judge?
Kamrup Metro.
Special judge Kamrup Metro. Okay.
Obliged.
26.
The records is not been received, I think.
Yes, Lordship. Lordship, may kindly fix a short date, Lordship. This matter is pending before additional district and sessions judge number 5 come with veterans of Lordship.
Okay, my filing my objection to date, sir.
You have already filed.
No, today
You're going to file. You are MS?
Kyukiba, Lordship.
Lolo, so and so. You are appearing on behalf of SK Nargis?
Yes, Lordship.
SK Nargis. Further also heard Mr. SK Kyle, the learned standing counsel NCB, and it is submitted that they are going to file their objection today. Further, further, the office note reveals the scanned copy of the answer is still not yet received. Issue reminder, raised you will do the needful. List accordingly. Short date as such we don't have, but we'll try.
Lordship, may kindly fix it next week because the petitioner is a widow with a minor son, and then she has been behind for almost 4 years now. As such, hearing is very necessary.
For 4 years.
Yeah, almost 4 years. Lordship.
Almost 4 years. Next week too, we do not have any date. In fact, at best 14/5 because we next week some matters are there. So we are not in a position to fix any date. 14/5 at best. 14/5. Okay.
Much.
Otherwise, we could have accommodated, but fixed matters are almost 30-35 in each a day these days. That's right. 14/5. Off.
27.
Lordship. My lord, FIR may be still page 10. I am a labor woman with my
small child. I went to work in the house where the meat was cutting. I am behind the bar since the 50 days. And my lord, co-accused of this case has been granted bail by your lordship. And so I am a lady, and the bail granted to that man, he was a man, my lord. So considering detention of 50 days and being a labor, she was working in that house. Somebody stolen the cow, and I was asked to pitch the meat. Saying that was my offense.
So being a lady, you also slaughtered the cows.
No, my lord.
Then?
Actually, I was called as a labor to cut this meats, and I was doing. I had no idea that it is stolen because I work in every person who called me at their house for work. I work, and thereby I earn my livelihood.
Main allegation against other persons, they were easily doing this thing, stolen cow and supplying this cow of it. And see, their petitioner is only because of this fact that she was aware of the fact that he's a stolen cow and they are doing this, but she was at the place of occurrence, she was there also. That is the allegation main going to the case. She was at the
Since when she got arrested?
She was arrested on 9th, so on 12/3/25, 50 days. 12/3/25, page 17 is the forwarding report.
Heard Mr. Emil Mahmood, the learned counsel for the petitioner, and also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application in section so and so in connection with so and so. City receipt to Mr. Singh. It is submitted by Mr. Mahmood that the present accused petitioner is innocent and she is merely works in other houses as a labor, and she is not at all involved in the alleged offense. However, the petitioner is in custody since last 50 days, and hence, considering her length of detention, she may be released on bail. Next paragraph, Mr. Goswami, the learned additional PP, submitted in this regard that she may not be involved in the stealing of cow, but she was aware about the stealing of about the same, and was engaged by some other persons in slaughtering and she was engaged by some other persons in cutting the meats illegally. Next paragraph, considering the submission made by learned counsel for both sides, and without going detail into the merit of the case, only on the length of detention, only considering the length of detention, I find that further custodial interrogation may not be required for the interest of investigation. To whose satisfaction it has to be?
CGM Kokraja.
To the satisfaction of CGM Kokraja. Okay, you are granted.
Hello.
Sometime he is going through it.
43 on the supply days.
40.
Lordship, regular bail, Lordship, commercial quantity NDPS, Lordship. There, Lordship, I am paying for bail on the ground of Lordship, Lordship. Arrest of ground was not communicated to the.
Just tell us before we proceed. Allegation, I'm not saying that it is a true fact, but the as for allegation, it was recovery was from you, or
No, recovery was not from me.
recovery was not from you.
Jawaharlal Moran, another accused. I filed additional affidavit, Lordship.
No, you're taking grounds of arrest and non-communication of grounds of arrest is okay. Just I'm asking you whether as per the FIR, you were caught red-handed or you were from position, a recovery was done.
No, recovery was made from one Jawaharlal Moran and Lordship, a petitioner is joint of Patil and his wife. Not.
Yes, Borwa, have you gone through?
My lord, 291 gram heroin, my lord.
Commercial.
So recovered from the position of the my lord accused person, my lord.
Position of the accused persons.
And searches submitted, my lord, on 29/11/2024, my lord.
CS on?
2024. 18 witnesses cited in the charge sheet, my lord. 18. And my lord, as per the last order, my lord, that is on 22/1/2025, my lord. The case was fixed on 5/2/2025 for consideration of served, my lord. After that, my lord, there is no update, my lord.
No, but why I'm asking, that there are two types of cases where I found that 29 is there or anyway, there may be involved. We are not on that, but on the last, these days, we are looking after that, whether the petitioner was caught red-handed with the contraband or he was subsequently arrested. That is the issue mainly we have to see.
My lord.
Here, what is the case? That's what I'm asking. They
So
may
here-
be involved, that is.
Here, my lord, they received the contraband. Then half of the contraband they have transported to Arunachal Pradesh, my lord. And half of the contraband they have handed over to some other person.
They received the contraband.
All persons are arrested. My lordship may kindly come to page number 43, my lord, of the bail application. Page number 43. Paragraph number 9, my lord. The FIR reflects that on 6/6/2024, on receipt of an information from reliable sources that one four-wheeler was coming from Hosai to North Lakhimpur, carrying huge amount of heroin in a Maruti Suzuki Swift vehicle bearing registration number so and so. The police party proceeded to Lakhimpur town and detained the said vehicle along with the person, namely, Maruf Hussain, Hussain Ahmed, and Ijaz Hussain, my lord. They were carrying the, my lord, contraband, my lord. On interrogation, these accused person disclosed that they carried 45 packets of box heroin from Hosai and delivered 20 packets to a person of Lalu and under 25 packets delivered to Srimati Tagar Patil and her husband Joyanto Patil, my lord. My lord, these are the, my lord, accused person, my lord. Of Saboti Lahar Dolong. Then the police proceeded to house of Sheikh Tagar Patil, wife of Joyanto Patil, and detained them. However, during the search, no any suspected item found in her house. But on interrogation, said Tagar Patil and Joyanta Patil disclosed that on 6/6/2024 at 8:20 p.m. they received this detained person, Maruf Khan, and his companion at NS 15 bypass, Uzoni Pohumara, and took them to Bordubi Sangsang PS, Panigaon, and received 25 packets of soft box heroin from Maruf Khan and his companion, and Joyanta Patil brought the heroin from the vehicle to the house of his father-in-law Jawaharlal Morang and kept the same there. Accordingly, the police proceeded to the house of said Jawaharlal Morang, where they found 25 packets of soft heroin kept in the white color plastic carry bag in his house, campus, and seized the same in presence of witnesses. On the other hand, as per information given by the detained person Maruf Khan before the CI Lalu police searched the house of Rajiv Pegu to take lawful action against him, hence this case. They were the receiver, my lord, then they delivered to my lord one, my lord, his name is Jawaharlal Morang, my lord. And from the Jawaharlal Morang possession, my lord, the contraband was recovered, my lord. Because these are the organized crime, my lord. That is why section 29 is there.
Yes, Mr. Burwa, otherwise the case is okay. 29 is there and they are the receiver, and as you have submitted that those were given to someone after receiving those packets from someone. But the question is that we are on issue that regarding the supply of or furnishing of grounds of arrest and all. So some matters have already been kept pending or deferred as because there is a caught red-handed matters or possession was direct recovery of the possession. But whether this matter can be heard in that regard, otherwise your objection is there. I'm not on that.
No, my lord, my humble submission, my lord. Since lordship is, my lord, considering, my lord, from probable protest of Gihan Kumar and Pankaj Bansal, my lord. Now, my lord, yes, regarding my lord, Supreme Court, my lord, this is not, I'll say, my lord, this is not direction, but in the observation in Gihan Kumar case, my lord, the section 50 has to be complied with, my lord. Now, my lord, since the retained case is pending before the Honorable Apex Court, my lord, the Honorable Apex Court made an observation, my lord. Roshime, kindly, I'm just reading the observation, my lord. We want to strike a balance. On the one hand, we don't want the mercenaries to misuse their power, my lord. That means, my lord, they have to comply the section 50 of the, my lord, BNSS now, my lord. Oh, sorry, 47 of the BNSS, my lord. On the other hand, we also don't want that the accused take advantage of some of our observation and get free, my lord. That is, my lord, whatever Supreme Court is, my lord, given in the judgment, my lord, in Gihan Kumar, my lord, that is the observation, my lord. That is why Apex Court is hold that, my lord, some of the accused person take advantage of some of our observation and get free. Justice Gawai observed during the hearing, my lord. That case is pending.
Whatever, but if you go by the Gihan Kumar, the observation is otherwise.
The 50 is not a new thing, my lord. Section 50 is, my lord.
Observation. is there.
BNSS, CRP.
Cannot deny it.
direction
Observation
there,
is total, complete observation was there in from the Supreme Court. There is there, even in rating, yes.
But, my lord, Lord Sime has to interpret it, my lord. Because Lord Sime is the Ernest Kumar, my lord, and Satendra Kumar until, my lord. Their Supreme Court has given direction, my lord. That's 42 has to be complied with, my lord. And even the, my lord, the copy of the, my lord, judgment of my lord Satendra Kumar until and Ernest Kumar, my lord, it was directed to the, my lord, all the registry to circulate in all the police stations, my lord. But in respect of Gihan Kumar case, my lord, there is no such direction, my lord. It is
Such
observation.
directions are not there.
It is the observation made in the Gihan Kumar.
Direction are not there, but if you go by
Clearly
wording,
clearly
it should
says
say
it
otherwise.
initiates the arrest, lordship.
No, my
And
question, my
lordship,
lord.
one more submission, lordship. Co-accused already been granted today in another court, lordship. Co-accused in this case, same case, lordship.
Place before the appropriate bench, then. My observation may be also different, that's what.
Secondly, my lord, I have another submission, my lord, regarding Caesar, my lord. Assuming, my lord, a person is got red-handed, my lord. That is, my lord, he was in conscious possession, my lord. Now, my lord, that means, my lord, he has already got the information that I am arrested because I was carrying, my lord, banned substance, my lord. That's why he has been arrested, my lord. Secondly, my lord, when the Caesar is prepared, my lord, he put his signature. That is the second, my lord, knowledge. That, my lord, why he has been arrested, because he has put the signature. Now, after that, my lord, he was taken to the police station for the purpose of interrogation, my lord. And before forwarding to the, my lord, judicial, my lord, for judicial, before the production court, my lord, the ground of arrest is submitted, my lord, or furnished, my lord. That is the requirement of law, my lord. I am not on that, my lord. Now, my lord, only question is that, my lord, as per the Honorable Apex Court observation, my lord, ground of arrest has to be furnished along with the details, my lord. Now, my lord, since the person is got red-handed, my lord, lordship is already hearing this matter, my lord. I am not making any additional submission on this regard, my lord. The person is arrested with banned substance. Seizure has been made from his position, from him, my lord. He has put his signature, my lord. After that, my lord, while he will be forwarding to the, my lord, judicial custody, my lord, that ground of arrest is mentioned that you are arrested in connection of so-and-so case under section so-and-so, my lord. So my
Now,
humble
see,
submission,
Mr.
my lord,
Borwa, everything is there. In fact, every accused, not even a single accused, they know why they were being arrested,
my lord.
why, what is the ground of arrest, why they were produced before the court, or why they were arrested. This is totally, I'm also admitting that these are the facts. In fact, these are the facts, in
My
fact.
lord.
But the question is that the grounds of arrest are now coming up in that manner that the written communication has to be, that we are on that only. We are also
That is
passing the order in
made
that
by
regard.
that is the observation made by the Honorable Apex Court, my lord. Your lordship has, my lord, ample power, my lord, to interpret the, my lord, those observations, my lord, considering the facts and circumstances of the each cases, my lord. This is my humble submission, my lord.
Okay, your matter is listing and then before appropriate bench?
No, lordship may pass appropriate or
Before the appropriate
orders
bench
in this
corridor.
case, not lordship, because lordship earlier, lordship has also passed
Observation
order.
may be
That's why it's
different also.
before this court, lordship.
Please before appropriate bench tomorrow corridor. List the matter on tomorrow. What is the date? List the matter on 30th before appropriate bench. Okay,
Lordship, earlier Lordship has passed orders in this case.
Yes.
Again,
Okay.
otherwise it will be go in.
Yeah, now you are saying that today only one order has been passed on. That's why
Then
I'm
Lordship specifically mentioned Lordship, Justice Kaushik Goswami's court maybe.
appropriate bench. He is also only taking the special bench, no one other benches.
Did,
Oh.
two more.
Tomorrow.
Day after, tomorrow. Lord.
Tomorrow.
Okay. All right.
Three and section 6 of the POCSO Act. And the length of detention is 80 days to the matter. 80 days to the matter. And one of the contentions of the petitioner is that there's a land dispute between the informant and the petitioner matter. And this POCSO case was lost as a fallout of that land dispute matter. Now, subject to what is there in the case diary, my lord, and your lordship may kindly consider the length of detention, and if there are any materials in support of that land dispute angle, my lord, that may also be the land dispute will be back. If there is anything to that aspect, my lord, land dispute and length of detention, otherwise your lordship may consider 80 days, my lord.
Regarding land dispute, lordship, there are some that I have not found any specifically. But lordship, 164 statement has been recorded. She has specifically indicated this person also.
And regarding land dispute, what she is implicating?
That I haven't done.
Because this informant and the petitioner.
Yes,
Respondent
some dispute facts are there lordship regarding land dispute lordship, but
Otherwise, there are implications.
they've been shooting for this ancestral property matter for considerable.
During the incident, she was 13 years of age.
she is only 13 years of age lordship, and 164 statement lordship, she is implicated lordship, whether land dispute because of land dispute in case lordship, that will help the petitioner lordship, that lordship may kindly see lordship.
That aspect will eventually come out in trial, my lord. Perhaps further detention at this stage may not be necessary.
And my lord, reflects also when she has threatened the victim. That also shows that.
Threatened.
That is there.
That is the FIR, my lord.
Threatening, even 164, it is also there. Also. May I place that 164 statement lordship?
Just tell us one more thing. Now, as Mr. Nawazi submitted, he is in custody for last 80 days. So whether there is any probability of filing the charge sheet within 10, 11 days, is there any? Is there any note in that regard?
There is also a delay of 1.5 months in lodging the FIR, madam.
Yes.
There is possibility. You cannot say that I cannot file. There is possibility also.
Medical is there,
Medical is there, madam. There is-
already collected.
If there has been rape, my lord, then perhaps medical would also clarify if there was any injuries to her private parts or any other sort of injury, my lord.
Medical report. Can records? How?
Well, in the first order, while calling for the case
Oh.
diary, it was also inadvertently written that scan.
Ah.
Nothing is there, my lord, only the order sheet.
Medical. Acha. Such medical report is, but I don't know when she went for the medical examination.
That is there also. Because there is also a delay of 1.5 months in lodging of the SR is there is a delay also because there is a treating parties also there, so that they did she didn't disclose it also. But as per in SR itself also it is written also that because of their treating lordship they could not lodge the SR lordship.
It is there.
That is interesting because this is always used as an angle to explain the delay. So the threat was there, so they did not go. Subsequently, when they went and lost the affair, then the threat automatically vanished. Considering these two aspects, my lord, length of detention and the possibility of that land dispute, because that is also come in that case diary, my lord. What should I consider? I have not taken the plea of grounds of arrest, my lord. I am only hoping that on length of detention, your lordship may consider. Otherwise, those were also not complied. Length of detention, I have objection because lordship, this is not a case where the only 2 persons are involved. Lordship. This is a crime against society also, lordship, and the one minor girl has been kept, lordship. So lordship, I have objection regarding length of detention, lordship, and land dispute, lordship, regarding land dispute, lordship, that will not help, lordship, because that may take they may take the ground in during trial, lordship, but during bail, lordship, for the purpose of bail, lordship, that may not be ground, lordship, because 164 statement, when there is a 164 statement and she specifically implicates, lordship, that that is sufficient, lordship. So lordship, regarding these 2 points, lordship, I have objection, lordship.
But yes, obviously, but I don't have found any note from the IO that the case is almost ready or willing to file the charge sheet. That is not there in fact. So today he is in 80 days. That much only I just want to say. Otherwise, there are some implications on how far it is true or false. That is other aspect. But the question is that I have seen is there any within Iman days or without charge sheet, but this kind of things are not here. That is one of the thing. Otherwise, there are some implications. I have some already. Medical may not support also because she was gone for the medical examination after more than 1 month. That may be one of the possibilities because recent sexual state may not be there or marks of violence may not be there also. Because the FIR was lost subsequently about one month later and then she only went for the medical examination. So that may not be there also.
Otherwise, at last, if it is not sustainable, what he will use that I also know, lordship.
Pardon?
At last, lordship, if that 2 grounds do not sustain, lordship, that length of detention and that, lordship, land dispute. And lastly, what arms he will apply, that I will know, lordship. Because that is because my learned friend has also gone to the CD and has seen that the IO has
not complied,
my lord. It's a constitutional mandate and
somehow they always forget to comply with the constitutional mandate. They're so concerned about arresting persons, but they always forget that after arresting persons, certain requirements are there which have to be followed.
No, Rasif, in from the very beginning, Rasif, the grounds of arrest that is mentioned, Rasif. But how the grounds of arrest is to be mentioned, that is not specifically from the very beginning. So,
That is understood.
sometimes the IO or police, the authorities thinks that Rasif, it is specifically mentioned the sections or and case number, it will sufficient. So now the case is that how it is to be written.
Obviously, obviously.
And in subsequent days, Rasif, we cannot say that there may be some other other procedure may come, Rasif, that this has to be like this way. In that case, again, we have to.
As and when that will come, your lordship will obviously examine.
So you also, this is also ground of arrest are not mentioned.
Not mentioned.
Heard Mr. S. Nawaz, Delaney counsel for the petition, and also heard Mr. B.S. Locko, Delaney additional PP, appearing on behalf of state respondent, and Mr. A. Fukan, Delaney, oh sorry, name is here. A. Fukan, Delaney amicus curiae, appearing on behalf of state respondent number 2. Okay, this is an application under section so and so in connection with so and so. City receipt, various same. It is submitted by Mr. Nawaz, that this petitioner is innocent and there was land dispute between the informant side and the accused, and the present case is only the fallout of the said land dispute. Mr. Nawaz further submitted that the FIR was lost only after 1 month of the said occurrence and said occurrence full stop. Further, he submitted that accused petitioner is in custody since last 80 days, and hence, with considering of length of detention also, his prayer may be considered. Next prayer, Mr. Nawaz also raised the issue of non-furnishing of the grounds of arrest in the arrest memo as well as the notice issued under section 47 BNSS, which violates so and so forth. Just with the observation to the basin line, Bihan Kumar and so on. Next para, Mr. Rocco Delaney additional PP submitted in this regard that there are sufficient incrimination in the statement made by the victim under section 183 BNSS as well as the statement under section 161 CRPC. He further submitted that the victim was only 12 years of age, 13 years of age at the relevant time of incident, and she fully implicated the present accused petitioner. So considering this part of considering this aspect of the case, the petitioner may not be released on bail at this stage. Next one, Mr. Fukong, the learned amicus curiae appearing on behalf of the respondent number 2 submitted in this regard that admittedly the girl was a minor at a relevant time of incident and she was also threatened by the accused and his wife, which also reveals from the FIR. Accordingly, he submitted that there may be the probability of the probability of hampering or tampering with the evidences of the witnesses cannot also be denied at this stage. Mr. Fukun accordingly raised objection and submitted that it is not a fit case to allow the accused petitioner to go on bail at this stage. Next, considering the submission made by learning counsel for both sides, without going in detail into the merit of the case, it is seen that the accused is in custody since last 80 days, but from the materials in the CD, it is seen that there is no probability of filing the charge sheet within the statutory period. More so, it is an admitted fact that the grounds of arrest were not communicated to the present petitioner, neither in the arrest memo nor in the notice issued under section 47 BNSS to the accused petitioner. Even detail considering to the violation of 21 of 22 ones of Constitution of India. Also considering the view of the Honorable Apex Court, so and so. Okay, will be granted to special judge who?
Special judge Nova, madam.
Special judge Nova.
I'm deeply observed.
We are not dealing with the matters wherein the court red-handed matters are there.
Because
others we are dealing with that.
Deeply.
I will fix.
Can be.
I am sorry, my lord. In this case, the petitioner was arrested on 10/4/2025. Election is this, my lord. The FIR was lodged by the police stating that they are in the place of occurrence after getting secret information and found a vehicle containing 5 nunks of cows, and when they reached, 3 persons fled away from the place of occurrence. Now, subsequently, my lord, that petitioner, he was arrested on 10/4/2025. Some persons also approached this honorable court, and this honorable court also granted interim bail to them, all the persons. Now, police are now searching so many persons. So, but, already 15 days today, he is in jail, and further custodial. Moreover, my lord, no notice has been served before the arrest, and even after arrest also no notice has been issued, ground of arrest, not punished, my lord. I make a statement before here, my lord. So, my lord, by considering the length of detention, and moreover, my lord, there is in fact no one has lost any affair regarding missing of the cow. No one. So, my lord, by considering the length of detention and vulnerable, that vulnerable owner was granted interim bail by this honorable court. And I am the person's no way connected, my lord. Name not affair. No one has lodged any complaint regarding missing of those cows. At least they should issue notice.
Now the question is that I can remember the case. There were 3 accused persons or the 3 culprits who fled away from the place of occurrence or from the vehicle, leaving the vehicle there in abandoned condition. So we do not know at this stage whether your petitioner is the one of the culprit who fled away from so and so. That's why we are seeking in fact.
In Lossocalise 14, he was arrested. 10, he was arrested. Suppose his involvement is there. So nothing hamper in the investigation of the case, my lord, if I have got.
No, if he is involved in such kind of thing, then obviously here further custody interrogation may be required. I don't know.
Well,
or may not be also.
But
So
the
let us-
Lossocalise paragraph 6, yes, should issue the notice before arrest. And after arrest also, even no information given to his family members and others, and even no ground of arrest has been communicated to the family members. So on
Let us
that
see,
count,
they will reveal everything then.
no, see, and now it is what happened, my lord. Now the police, what is they going to do? They arrest the persons. Immediately took their signature paper and prepare it as a notice. Now that is going on, my lord. But before that, they should issue a notice, my lord. So you should come in the police station, you are required in this kind. That has not been done in their present case also. Now, my lord, after arrest, even after arrest also, no information has been given. So, my lord, only 15 days I have.
We are trying to give a short.
65%. My lord, on 8, another case is fixed.
On 8. Okay. CD call for 8. Okay, we're fixing it on 8.
12.
We'll put everything. You have kiba question now? So your case is along with 45.
Along with no, both are different cases, Lordship.
And then you are saying 45 is also there?
45 is also there.
You are
I
appealing for
mentioned,
in the 45 also.
yes, Lordship, that's 12, Lordship. So I'm taking this method 12, Lordship. The POXO case and pending before the Rongia POXO court, Lordship. And scan copy of the case record was called for.
Just
Unfortunately,
tell us one thing, whether the your notice is been served?
Service completed, madam.
Service completed.
Americans may be appointed, madam, since they have not appeared.
Lordship, last occasion, there was a confusion regarding the 164 statement of the victim person that was incompleted. So your Lordship was pleased to go through the 164 statement to reveal, is there any love relationship between the parties? As because accused is 21 years old and she is 17 years old. So your Lordship was pleased
Why
to.
scan copy was before us?
Yes,
Earlier it was called for.
Yes, Lordship.
Oh, you have already appeared.
Just the Government party was here, but I couldn't find the Galatama.
Okalatnama, acha, acha. Otherwise,
Can
we have
receive
received
one.
this scan
Yes,
copies.
this can receive.
On the last occasion, there was some submission was there that
Yes,
the recording of 164 is not completed. One part is there, one part is not there.
yes.
It is completed. They have inadvertently, most probably it was not taken. So now Mr. Hawk is appearing for the respond number 2, most probably. So if file Vokalatnama and if there any oral submission or verbal submission will also can satisfy us. So in that case, you can
If he's ready for oral submission.
Just half an hour prior.
file your Vokalatnama.
So I'm languishing in jail from 14/5/2004. And charge sheet was filed on 2014 loss, 2024. On 30/5/2024, charge sheet was filed. I was in jail. But after 8 months, that is 10/9/24, the prosecution has issued, a call for evidence. They have taken 9 months since I was in jail.
As per your instruction, what is the position now? Is
This
victim
is
has
for-
already been examined?
No, victim is
Not
not
yet.
examined. Yes. Lordship may go through the 164 statement and
Let him be ready. Mr. Hawk is not ready, I think.
As per an appointment, I have more than 2 matters were sent today. It is not possible. Now, one is doing inspection and I will submit the written objection of solution. In the meantime, also victim may be examined and later perhaps 9/5.
Yes, sir.
9/5.
Because 183 statement, my lord, he has implicated, my lord. Although there is a love affair, my lord, but my lord, accused person, he has not stated her that, my lord, he was already married and my lord, father of a son, my lord. By misleading her, my lord, he took her, my lord. Then indulged in physical, my lord. After that, when she came to know, my lord, then she came from the, my lord, position of the accused person.
it's a different angle, Lordship. By concealing something, he may, but in case of POXO, due to love affair, she went with
The POXO come, my lord, only because of her age factor, my lord.
Yes.
Because as part of date of birth seized by the, my lord, investigating officer, my lord, she was minor at the time of incident.
So let the matter.
Heard Mr. A.K. Sharma, the learned counsel for the petition. And also heard Mr. R.J. Boga, the learned additional PP appearing on behalf of state respondent. And Mr. F. Hawk, the learned counsel appearing on behalf of the respond number 2. However, Mr. Hawk submitted that he yet to be, the Wakalatnama is yet to be filed by him as he is engaged by the informant today only. Further, Mr. Hawk submitted that he needs some more time to prepare the case and to file written objection, if any, and accordingly prayed if any, full stop. The scanned copy of, however, the scanned copy of the case record has already been received. Full stop. Next para, I guess when it can be listed then.
So my submissions was 9/5 is the
Date.
evidence for
After
victims.
that, it would be, should be.
Better.
It may
Yes, sir,
benefit
victim
Mr.
exam.
Sharma also.
This is also my submission, my lord, after according to the statute of the victim, my lord.
Right.
The bail application may be considered.
Yes. 20 will do. 2020.
Before 20 Lordship, because on the 14th Lordship, because on 9 evidence will be kept. 14th Lordship.
Then
because
16, not 14.
16th.
Oh.
Yes, and 16th.
My lord, then my lord, the up-to-date status report may be.
Yes,
called for.
16/5 and up-to-date status report of the case be called for, along with the evidence of PWs, if any. Registry will do the needful. Yes, what is your 45 now?
45 Lordship, we have taken step to the victim person.
You have not taken steps as per note.
Yes, Lordship, we have taken step.
No, you have not taken steps.
We have taken step, Lordship, but
On 28/4, you have taken steps yesterday only. Yesterday only you took steps. I don't know if I'm from,
It
I'm
was,
from
yes,
this.
Lordship, but we have taken step immediately before, after 2 days of last hearing. But
Last date was fixed on 4/4
4/4.
and thereafter you took steps.
Yes, Lordship.
But it is received by only on 28/4. Why? Hey, that's why the service is still awaited.
Definitely, Lordship. Anyway, Lordship.
Hawk is appearing here also.
No, that is
No.
like 45.
No. Yeah, we are on 45 now.
45, item 45.
45 would mean high.
No.
It will, 12 to hold.
Anyway, though it was order was on 4/4 and should be returnable within 29/4. So we are listing it on 29/4, but steps seems to be taken on 28/4 only. That is the as per office note. It was too late then. So that's what we're awaiting the service. Anyway, we'll instruct we take some instructions. Hard Mr. A.K. Sharma, 45 to hard Mr. A.K. Sharma, the non counsel for the so and so. And also hard Mr. R.J. Borga, the non-additional PP so and so. From the office note, it is seen that the steps were taken only on 28/4/2025 for the respond number 2, and the service is still awaited. However, Mr. Borga, the learned additional PP is hereby asked to take instructions regarding the service of notice on respond number 2. List the matter accordingly. If our last one was 14/5, we are also this one is also listing on 14/5. 16. She's saying 16 should be. 16.
Deeply applied.
Madam, we have received the case diary, so we'll attend the case diary.
Case diary is already received.
Received.
CD received. Retain the case diary till next date of listing. Okay, then we are listing it, retaining it.
Madam.
19.
Yes, 19.
May please lordships. In this case, my lord, the quantity relates in this case, my lord, to the intermediate quantity, my lord.
Okay.
And already, my lord, he is in jail my lord, for 59 days, my lord, as on today, my lord.
59 days.
59 days, my lord. On my lord,
He got arrested on when?
was arrested on 2/3/25 and picked up from my lord 1/3/2025, my lord. As on today, my lord, it counts from the date of his arrest, my lord, forwarding, then my lord, 58 days, my lord.
We have received a case driver FSL report notice.
My lord, everything, my lord, 58 days, my lord, and the intermediate quantity, my lord. Then, my lord, your lordship, my grant bail, my lord. As because, my lord, only statutory period is 60 days, my lord.
And recovery was made from the petition.
My lord, in this case, my lord, two persons were arrested, my lord, my father and son. My lord, son has already been declared as, my lord, a juvenile, my lord. And he is, my lord, in custody of the mother of the juvenile, my lord. And now, my lord, he was doing as, my lord, hardware shop, street shopkeeper, my lord. And on the LS day of occurrence, my lord, kindly have a look at page, my lord. Page seizure list, my lord. Page 15, my lord. My lord, very surprisingly, my lord, the police, as per FIR, my lord, the police got information, my lord, at 8:24 PM, my lord, and thereafter they have prepared for their mission, my lord, and which took some time. But thereafter at 9 PM, my lord, at 9 PM, while the petitioner was closing his shop, my lord, and then, my lord, he was picked up, and it was, my lord, in the seizure list, it was recorded that the date and time of seizure, that is, my lord, 1/3/25 at 10:20, my lord, 10:20, sorry, my lord, 8:20 PM.
Okay, we do not go detail on the merit of the case at present.
Yes.
Part 19.
2 days remain, my lord.
Heard Mr. S. Amit, the learned counsel for the petition, and also heard Mr. D.P. Goswami, the learned additional PP so and so. And this is an application section so and so in connection with so and so. It is subject CD received, perused the same. It is submitted by Mr. Amit that the present accused petitioner is in custody since last 2/3/25. That is still that he is in custody for more than 58 days, and hence, considering his length of detention, he may be embarrassed on bail. Mr. Ahmed further submitted that it is a case of intermediate quantity and hence rigor of section 37 will also not follow in this case. Mr. Gusam next para, Mr. Gusami, the learned edition PP submitted that there is sufficient incremental materials against the present accused petitioner showing his direct involvement in the alleged offense. However, the IO could not collect the FSL till date, full stop. Next para, considering this so without going detail of the merit of the case code. To whose satisfaction it has to be?
Special Judge Kamrup Metro at Guwahati.
Special Judge Kamrup Metro.
My lord, surety, my lord, one.
He is from where?
Kamrup, my lord, Gorsuk PS, my lord.
No,
Under
no.
Kotavari village. Kotavari.
Village.
Yes, my local. my lord.
We'll see you see the record.
Yes, obliged, my lord. Much obliged.
The matters after one, most of the matters may be adjourned. That may be at 2 or afterwards, I don't know. As to the Arunachal is at 2, huh? And Justice Surana, along with Justice Surana, it will be at 3. So after Arunachal, if some time is there, then we'll can.
28. This is the Lordship. My lord, the petitioner before the Lordship was arrested on 13/12/2023 on a statement made by a person who was apprehended along with alleged contrabands, my lord. An FIR was lodged by the prosecution, my lord, on 11/12/2023.
He was arrested along with the contraband?
No, ma'am. He was not. He was arrested after 2 days, and on spot interrogation, the apprehended accused person said that his name, my lord. So he and along with another my lord, person, Wahid Hussain, was arrested by the prosecution on 13/12/2023, and since then, my lord, he is in custody. And my lord, the prosecution also laid charge sheet in this matter on 29/2024, citing 9 witnesses. 29/2024, citing my lord 9 witnesses, and out of them they have already been they could have examined my lord 2 witnesses. Now, my lord, here in this case, I have also my lord raised the grounds of my lord. Lordship will kindly peruse Annexus 7, my lord. That is, my lord, at the time of my arrest, my lord, nothing has been disclosed. And nothing was recovered, my lord, that Lordship FIR itself clarifies. And my lord, seizure list is also there. Lordship will find that from whom it was seized. I have also got the certified copies, my lord, and it is also in the record. That
Page number?
Page number, and my lord, it is 53, my lord. My petition, present petition. And my lord, another aspect, it may just Lordship has got it, my lord. I have the certified copy. My lord, along with the present petitioner, one of the accused person was apprehended, my lord, was also arrested. He approached the honorable court, and Lordship was pleased to release him by order dated 5/4/2025. If I may just place this order, my lord, for Lordship's perusal. I'll also supply a copy, my lord. In fact, 2 persons were already released by this honorable court, my lord. He was the person, my lord, along the present petitioner was arrested, my lord. That applicant in bail application number 360. So, my lord, considering the prolonged length of detention as well as, my lord, the violation contained in the provisions, my lord, and nothing has been recovered, Lordship, but the FIR is very clear. Seizure list is also clear, my lord. That contraband was recovered from 2 persons, my lord, one Shiabuddin and one Abdul Manna. From them, some contrabands were recovered. They, my lord, Shiabuddin, my lord, confessed that he is also involved. But he was not at the spot, my lord. After 2 days, he was arrested, my lord, from his house. Forwarding is also there, my lord. I have the next page 2020, my lord. local person residing within the jurisdiction of the special court itself. So my lord, not free or there is no chance of responding. And lordship may also put one stringent condition for securing his attendance, my lord, for the trial court for facing the trial, my lord. I'll abide by any condition, my lord, in the event lordship considers my conditional, prayer for conditional release, my lord.
Yes, Purva.
My lord, my submission, my lord, since my lord, I appear in the case, my lord, my submission will be same, my lord, in respect to paragraph 9 and my lord 10, my lord. Of the lordship's order. my lord. Paragraph 9, my lord, although there is some mistake, my lord. Paragraph 9, it should have been Mr. Burwa.
Oh. How it can. Pulo এসি এটা। এটাই পরিচিত এটা। It's a para 9 not, para 9. Mr. Alam হয়েছে না? Additional fee. Num 2. That should be corrected.
My lord, as far as this case is concerned, my lord, although my lord, the contraband is not recovered from this position, my lord, but my lord, as per the going to statement, my lord, it was supposed to be delivered, my lord, to this accused person, my lord. If the contraband is not seized or my lord detained, my lord, the accused person is not detained, my lord, they will deliver the contraband to this accused person. Accused person, my lord.
Then
This
the
is fact
scenario
of
would
the
have been changed.
Scenario would have been changed, my lord. Now, my lord, as on that, my lord, 2 witnesses examined, my lord, they are Caesar witness. They have implicated the person, my lord, from whose the contraband recovered, my lord. Yes, admittedly, my lord, because the contraband was recovered from not from this position, my lord. It is recovered from the position of the accused person who carried that contraband, my lord. So BW 1 and 2, they have implicated them, my lord.
Not the present petitioner, my lord. From the person.
Definitely, my lord, because he is the receiver, my lord.
Yes, he is a receiver only.
Till the, my lord, Caesar, my lord, he has not come into the picture, my lord.
Obviously.
My humble submission, my lord, that is, my lord, para 9 and 2, that will be same, my lord. And apart from this, my lord, if the person is not arrested, my lord, they will deliver the contraband to this person.
But it can be at our level, only get a million 9 on the basis of weight is to provide. I will be the side of it to live it only.
And there are some delay occurred, my lord, because one of the accused person is still absconding, my lord, probably, my lord.
Statement of weight. Two witnesses to examine. In লিখা আছে না? বাকি all are same. It was 9. And in the prosecution examine, 2 examine is already there only. It was passed on 5/4/2025 and today is 30. So days of herit all of on difference of a name of the petition.
It is 503 days, my lord. 503 days.
I don't know all are same. Okay, Mr.
Officer reflected my submission, my lord. So, my lord, this I have referred to the my lord, paragraph 9 and 10 of the order.
Yes, obviously.
Lordship, not looking. Yes. Looking.
So, my lord, searches submitted, my lord.
29 charges submitted. Are you on interim?
Lordship, petitioner number 2 is on interim. Lordship.
2 was on interim.
Lordship.
1 was not on interim. 2 interim to extend for development. So for 2, we are extending this interim up to 15 days and appear before the learned trial court bureau with a regular application for the bail that may be considered in accordance with law. ESCS number?
My lord, searches number, my lord, 31/2025, dated 31/2025.
Okay. Only for 1, 7. Petitioner, no? Petitioner number 2 was on interim.
Lordship.
Yes. Yes.
31.
May it please, Lordship. Lordship, this is a 482 application
Lordship, kindly come to the page number 13, Lordship. This FIR in vernacular. I'm perusing the FIR. এজাহারকারী বিনীত নিবেদন এই যে মূর নাবালিকা ছোৱালী সোয়েনসু বয়স 18 বছৰ 9 মাস বৰ্তমান উচ্চ বিদ্যালয়ৰ প্ৰথম বৰ্ষ প্ৰথম শ্ৰেণীত পঢ়ি থকা ছোৱালীজনীক উক্ত আসামীয়ে মিছা প্ৰলোভন দি গোপনে ভাল পাই আহিছে আৰু বৰ্ষাবৰী চকত ফুৰাব লৈ যাব বুলি মিছা প্ৰলোভন দি গোপনে উক্ত ছোৱালীজনীক চৰত নীৰৱ ঠাইত নি তাই ইচ্ছাৰ বিৰুদ্ধে যৌন সংযম কৰে আৰু গোপনে উলংঘ অৱস্থাত উক্ত আসামীজনৰ মোবাইলত ফটো মাৰে কিন্তু উক্ত আসামীজনৰ লগত বিয়া হোৱাৰ কথা কোৱাত তাই অমান্তি হোৱাত উক্ত আসামীজনে আজি বহুত দিনৰ পৰাই নানান ধৰণৰ ভয় ভাবুকি দি অহাৰ উপৰিও গোপনে উঠোৱা ফটোসমূহ মোবাইলত ভাইৰেল কৰি দিয়ে তাৰ লগতে নম্বৰৰ পৰা দৈনিক মোবাইল নম্বৰত উক্ত ভাইৰেল ফটোসমূহ পঠিয়াই থাকে বৰ্তমান উক্ত ছোৱালীজনী উচ্চতৰ মাধ্যমিক বিদ্যালয়ৰ প্ৰথম বৰ্ষৰ ছাত্ৰী হয় আসামীজনে অপহৰণ কৰি নি হত্যা কৰিব বুলি ভাবুকি দিয়াত কলেজত যাব নোৱাৰা পৰ্যায়ত পৰি আছে উক্ত আসামীজনে মোৰ স্বামী তথা মোকো প্ৰাণে হত্যা কৰিব বুলি ভয় ভাবুকি দি আহিছে উক্ত আসামীজন ছোৱালীজনীৰ জীৱন ধ্বংস কৰি আহিছে আনহাতে উক্ত ঘটনা সংক্ৰান্ত দুই নং আসামীক অৱগত কৰাত উক্ত আসামীজনে এজাহাৰকাৰী তথা পৰিয়ালৰ সদস্যসকলক অশালীন গালিগালাজ পাৰি ঠেলা গাঁটা মাৰি ভয় ভাবুকি দিয়ে আৰু উক্ত ঘটনা জনোৱা পিছদিনাৰ পৰাই দুই নং আসামীয়ে চক্ৰান্তমূলকভাৱে অভিসন্ধি কৰি 1 নং আসামীক অজ্ঞাত ঠাইত লুকাই ৰাখিছে যাৰ ফলত মান সন্মান লাঘৱ হৈছে প্ৰকাশ থাকে যে উক্ত ঘটনা সংক্ৰান্তে যোৱা ইংৰাজী 24 তাৰিখ মৈৰাবাৰী থানা এজাহাৰ দাখিল কৰা হৈছিল যদিও থানাই এজাহাৰ পঞ্জীয়ন নকৰাত উক্ত আসামীক গ্ৰেপ্তাৰ নকৰাত মহোদয়ৰ জৰিয়তে উক্ত এজাহাৰ কৰি মৈৰাবাৰী থানালৈ দিয়াত বৰ্তমান মৈৰাবাৰী থানাই কোনো ধৰণৰ গুৰুত্ব নাই This is the FIR. Lordship. And Lordship, the victim is 18 years 9 months. I am also 18 years old. Lordship. And the actual fact is that Lordship, we had love affairs with the victim. I had the love affairs with the victim, and this is a consensual relationship. Lordship. Lordship, kindly come to the page number 4. Lordship. This is my petition. The actual fact of the case is that the petitioner and the victim have been in deep love since long day. Presently, the victim is a major girl and she is entitled to have right to choice under Article 21 of the Constitution of India. The victim forcefully took the petitioner to Borchapuri Chowk or Char area. The victim forcefully took the petitioner to Borchapuri Chowk or Char, as both of them are majors. The obscene photos have been sent by the victim out of her love and affection to the petitioner. The petitioner sent marriage proposals to the parents of victim, but the victim's parents don't have their consent for tying the knots between the petitioner and the victim. The victim is not ready to get married to another bridegroom other than the petitioner. This was the conspiracy of the victim to compel the parents for their social marriage. Hence, this section does not attract. So, Lordship, the seizure list, the obscene photos have been seized is number 16. Lordship. The obscene photos have been seized from the victim, not from me, Lordship. In the page number 16, has been mentioned. Total 19 number of obscene photos have been seized from the victim, not from me, Lordship. So not from my mobile, Lordship. So, Lordship, I am also 18 years old. I am marriageable. I am not marriageable age, just 18 years old. But I sent the proposal for marriage. But whenever they are not interested to get her married with me, that's why they have filed the FIR. And the relationship was consensual. So this does not amount to rape, Lordship. The pattern of judgments of Supreme Court of India also said. So, Lordship, in this ground, and I may kindly be allowed to go on bail. For a 180 statement, he implicated the petitioner also. And 19 obscene photographs were seized, and for a statement of the witnesses, it was viral. So, Lordship, being in a relationship, it is acceptable, but having the photos of the obscene photos of a girl or women, Lordship, is so my humble prayer before your Lordship that it is not a picture granting and
His mobile handset is recovered or no?
His mobile photograph was taken from victim mobile. He was sent.
It is the allegation that it was, those were made viral.
Made
Those were made viral,
made-
it is the
made
allegation.
viral
So
by
that's
this-
why whether the mobile handset was recovered?
Made mobile insurance of other witnesses. It was viral to other person. That is the statement of the witness.
From the mobile of handset of the accused itself.
Yes,
That's what
that
I'm
was,
asking,
that was
whether
not seized.
not seized.
Not seized.
Why not seized then?
The her statement of when she refused to marry him, he filed the photographs.
This was not my fault also, Lordship. I am ready to get married, but she is not impacted. Her family is not impacted. She is also impacted. It's not a false promise to the victim. And the publishing of obscene photo is attracted to 67 section. It's 3 years imprisonment of the simple punishment. We can allow one bail. I will appear in before the IU time to time.
We are on 31. Heard Mr. M. Rahman, the learned counsel for the petitioner, and also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application, the section so and so, in connection with so and so. City received fails to see. It is submitted by Mr. Rahman that the present accused petitioner is innocent and he has not committed any such offense as alleged in the FIR. He had love affairs with the victim, and even if there is any relationship between the if there is any physical relationship between the parties, it was purely consensual, and out of the said love and love affairs, the accused also proposed to marry the victim. But the family members of the victims were not interested to give marriage to the accused because as he was also 18 years old boy. But the petitioner is still ready and willing to marry the victim if she gives her consent. Further, he submitted that all the from the seizure list itself, it is seen that all the obscene 19 numbers of photographs were seized, not from the possession of the accused, but from the possession of the victim herself. The accused is ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of the arrest bail. Next bill. Mr. Goswami, the learned edition PP submitted in this regard. The victim had implicated the present accused petitioner in her statement made under section 183 BNSS. And though she admitted the love affairs between them. Further, he submitted that 19 numbers of photographs were already seized from the possession of the victims, which were already made viral by the accused petitioner. Mr. Goswami accordingly raised objection and submitted that it is not a case to allow the accused to grant it the privilege of pre-arrest bail to the present petition. Hearing this submission made by learned counsel for both sides, I have also perused the case diary. And considering the materials in the case diary and other aspects of the case, I find that it is a fit case to extend the privilege of so and so. Okay, you are granted with the privilege of interim pre-arrest bail, appear before the IO and cooperate in the investigation of this case.
Obliged.
তেখেতক সুধো নেকি? হয় নেকি? কোনটো? Mr. Chaudhary, you were waiting, that's why I just inquired with my courtmaster that what is your matter? So they, she's saying that it is a hearing matter.
39.
39. But the question is that at 2, I have some matters with Arunachal.
Yes.
And then at 3 p.m. one division bench matter is there with Justice Surana.
Let it be on some other.
So it may not reach, I think so.
My lord.
So if otherwise this, it may also be a part of that will be create another problem. So I think better to
Let
take
it
a
be on
date.
some other day, my lord.
Yes, because from 3 onwards, this bench will not be available. We are a division bench.
My lord.
So that's why I thought we were sitting there. So I just inquired about the case, what is
My
your
lord.
case? Then she told me that it is a hearing matter. So other day, in a sense, it will be on a hearing day, I think. Hearing day, 29/5 will do. 29/5 due to positive type, we do 29/5. Okay, we're listing it on 29/5.
Only there is an interim order, my lord. That
Interim order was there. Interim order be continued till next date of listing. We'll
obliged.
extend it.
Obliged.
Item 9, that is an admission matter. Perhaps that may also not, it's a part-heard matter, my lord.
It was a part-heard
Part-heard
matter.
matter. Your lordship will remember
With
that.
whom it was there?
Yes, lord.
With you, na? So we'll, after finishing the Arunachal matter, it may take 10 minutes also, it may take 1 hour also. I don't know at this stage because it is in order column. If hearing is there, then it may take some time. If hearing is not there, then I may rise by 2:10 or 2:15 like that. In that case, maybe heard, I don't know at this stage. I cannot say at this stage because 2 benches are there. Again, 1 bench is there from division benches there. That's why. If time permits, then because it is a part-heard matter, that's why I'm saying. It is a part-heard matter, so if time permits, then it's okay. Otherwise, wait till 2:10, 2:15. Let us see what happens.
Lordship,
Yes, item
33. So here I am on interim protection and I have duly recorded my statement, appeared before the concerned IO on 7th of April.
You are one direction was there that.
Yes, on 7th of April, I have duly appeared and I have recorded my statement. Now, today has been fixed for receipt of case diary. So I have come to know that CD is there. But now the fact is that learned counsel, he is on legs again. So now again, I had to, lordship will be sitting there. So if there is any paucity of time, then we can take up on another day. Till that time, interim may be extended.
Or lordship can take it after the lordship Arunachal matter, lordship.
Arunachal bench.
If time permits, lordship.
Then okay, then for time being it is kept. Then after at 2, let us see when if time permits. If time it permits, your matter is there. One part-heard admission matter is there also. The rest, so I think maybe adjourn also. I don't know. Then up to 2 at 2, we'll try make a try. If submission is there, and if it is 2:10, 2:15, this is not possible, then you take an adjournment and will not fix another date in that case. Otherwise, he has appeared already. You have already.
Yes, I have it.
Okay.
And I'm cooperating with all the conditions.
On 7th, I think one date was there.
Yes,
7th.
he had come down. Though he was not well. In fact, on the day of recording his statement, that day also he was a bit late since he had some sort of chest congestion and then he had to take some medicine. And then again he finally appeared a bit late, around like 12. Because I was not there, later on I came to know that he had appeared.
But lots of materials are there in the case diary.
Pardon?
Materials are there in the case
Yes,
diary.
if it is okay, fine. He's cooperating and
You can submit on that.
Yes,
basis if matters are
absolutely.
there. But I am not. It is not confirmed whether it can be taken up or not. But we'll try it.
if it is not taken, my lord, then interim maybe.
Yes, because Arunachal matter may take on 10-15 minutes also. And if hearing is there, because it is an order column, there are some issues regarding the maintainability. If hearing is there, then it may take some time.
They have raised 3 grounds. One ground was of social media, which themselves during their election petition has said that social media cannot be the ground either for removal or for disqualification. Now, for only 2 questions remain, 2 grounds remain. That is, one is of criminal antecedents and another is of a corrupt practice. And regarding the accommodation, now I have raised some questions.
Where are the questions? Yep.
Questions is in page number 9 in Excerpt 1. So this I may be allowed, your lordship, for them to answer. page number 9.
Whether
Your
in
Lordship.
IA,
3, 4, 5, 6. Mainly 6 questionnaires are there.
Yes, yes, Your Lordship. Meanwhile, they have filed adjournment. I have received a copy of seeking for adjournment for today's matter, Your Lordship, from their side. I have received one copy just now. The election petitioner, they had seek for some time.
Yes, Mr. Kato.
may I please, your lordship? In my lord, IA, my lord, I may be given some time to, my lord, the reply. My lord, it is not required, in fact, number one, my lord. And my lord,
My simple question is that there's some questionnaires are there as put by Mr. Rakshap in 6 numbers of questions are there. Interrogatory.
yes, my lord.
So do you think it is your part to answer those questions? Because
No, my lord, no, my lord, it is not required, my lord. Not required, my lord. That's because election petition is completely, is to be decided on its own merit, my lord. So therefore, my lord, I'll file objection.
But Mr. Rakshap, this will help you in deciding the, or it will make easier for the election petition. That is
Yes, absolutely, Your Lordship.
My lord.
Your Lordship, I have filed it for some reason, which will help us, all of us, in deciding this
issue,
trial.
my lord, issue, by framing issues, my lord, everything will be covered up, my lord.
Your Lordship, if they answer this questionnaire, Your Lordship, I will file a preliminary issues, Your Lordship. That preliminary issue with preliminary issues only we can decide the trial matter once they answer. Because their election petition.
At this stage, my lord, I may be given some opportunity to file a reply in this IA, and my lord, the proceedings may be held expert as because today we haven't received any copy for adjournment from the, my lord, on the last occasion, if your lordship peruse the order of the last, my lord, the last order of your lordship. Today is the date fixed for, my lord, the framing of the filing of the, my lord, suggested issues and the documentations, my lord. Documentation and the issue is the, my lord, is at this stage. But my lord, I haven't received any, my lord, IA for the adjournment on the part of the, my lord, the respondent, my lord. So therefore, my lord, the
Whether you have filed your draft issues. Whether
no, my
you
lord,
have filed your draft issues.
no, draft issues, my lord, I'm seeking adjournment by filing, my lord, IA 114 for granting some more time, my lord.
Just tell us I-114.
Yes, my lord.
I-114.
Is my my lord. Yeah.
No. 114 is 114 is for filed by Rakshap only. Your IA number is your for adjournment IA number is we have not received
My
that
IA, my lord, that IA, my lord, I'm not sure, my lord, that is transmitted to your lordship or not, my lord. But with this IA, my lord, which I have filed is for, my lord, basically granting of the adjournment for today.
So just
and
tell
my
us
lord,
number of the adjournment.
114, my lord.
I. What? 11?
4, my lord. 114.
114 is the 114 is in here.
And there IA.
114 is filed by Rakshap.
Your Lordship, 114 is their IA, Your Lordship.
It is my IA, my lord.
Oh, 114 is their IA. And your
no,
IA.
114 is my IA, but I have received their IA just now, and this is not numbered, Your Lordship, actually.
Not yet numbered.
I'm sorry, my lord. 114 is their IA.
114 is my IA, Your Lordship.
This IA is 114 IA is basically filed by the respondents for, my lord, the putting some, my lord.
Yes, they have put some questionnaires there or
Yes, it is for interrogatories, Your Lordship. Meanwhile, Your Lordship, in their IA, they have sought for some time, and since they have to obtain some documents from the concerned authorities. Your Lordship, I think for their side also, it will take some time to obtain because the functioning of office. I am also seeking for some documents. They are yet to furnish me. So Your Lordship may grant some time for with regard to issues, and the reason why I have not filed this documentation is that if this all questionnaires is answered, Your Lordship, then there is a I will file an striking of petition, because their election petition is so voluminous, but within that election petition, your lordship, they've raised so many issues, but which are not at all relevant for our case, your lordship. So some portion like the social media issues, the ground that they have taken, they have said that social media cannot be the ground for disqualification either for removal. So those petition, those clauses are not required, your lordship. So if that are striked out, then the our petition will become your thinner. So that will be helpful for us in while framing issues. Otherwise, I have to come up with all those issues, your lordship, whatever they have mentioned. So that is why I have raised this IA. So in the next time, I will I will file an IA for striking out. There is a provision that helps the court and us also, your lordship.
Malad, I'm sorry, Malad. My IA is 115, Malad. Malad, at this stage, Malad, may I pray that Malad, I'll file objections to the IA filed by the Malad, the respondents. Malad, the entire thing will be Malad come up in the framing of the issues, Malad. Whatever the Malad regarding every aspect, Lordship has already heard on maintainability, by which they have raised everything, that has already been decided. Now this is the stage of the framing of issues and the documentations, for only issues and documentations, Lordship may fix the short date. In the meantime, we'll file the documents and the issues, suggested issues, and this IA is basically in other aspects, that may help or may not help. The election petition has to be decided, So therefore, may I pray that the next that may be given, In the meantime, I'll file documents and the issues, suggested issues, And regarding this IA 114, I'll file objection separately, This is not, at all, required to be, decided at this stage, Election petition is to be decided separately,
Your
Otherwise,
lordship,
also, if you file some draft issues or document, whatever, it is the duty of the court to frame those issues.
Yes,
so
madam.
It
Yes,
goes
madam.
through with which are these are relevant or irrelevant. That will be
Yes,
decided by
yes,
the
madam.
court.
Yes,
But
madam.
yet, if Mr. Rakshap says that it may help this is a voluminous petition filed by you, raising many other issues which may not be relevant or may be relevant or may not be relevant. That is
Correct, madam.
into. Okay, then we are giving you some more time,
Yes,
Mr.
madam.
Kato, to file your objection.
Exactly, madam.
114 had Mr. Arakshan, the counsel for the petition, and also had Mr. M. Kati, the counsel appearing for the respondent. And by filing I number 115 of 2005, and he sought some more time. In 25, we sought some more time to file the written objection in that regard. Prayer allowed, list matter according to when it will be convenient, both the matters will be listed together. When it will be
Matter may be fixed on 13th of May, Malad. 13th May, Malad.
13th of May, your lordship, 13th of May, okay, your lordship. That will be fine. 13th of May, okay.
hearing matter. Oh, just a second. There are another matter, ownership matter is fixed on 13. It will take time, I think, for that will be heard from the principal seat itself.
Okay, madam. Then in that case, Malad, 14, Malad. 14, madam.
Are there, so may not be possible on 13th.
Yes, madam. 14, madam. 14 am juai. 14.
Okay.
Let it be on 15 then. 14 are also
Malad.
there.
Malad.
15 করে দিব।
Yes,
আর 15 করে the hard sales করে দিব। Here the R2 is the election petition. Is the respondent. Both the time, but parties are hereby allowed some more time to file their draft issues and the documents. List accordingly. Okay, both the matters we have fixed on 16/5/2020.
Malad.
By the time you can
Deeply
file your
obliged.
issues as well as what's it?
Malad.
Oh.
Much obliged.
Much obliged. ये जो
Please, Lordship, I beg to mention item number 41 of the daily list, Lordship. I have taken consent of the petitioner side and making a mention on behalf of Mr. D. Gogoi, amicus appointed for respondent number 2, item number 41. Hearing matter, Lordship.
Objection.
I have taken consent of Mr. Bimal Chetri, Lordship. In fact, he told me to take an adjournment after 3 weeks, to take a date after 3 weeks.
So you are appealing for Mr. B. Chetri?
No, Mr. D. Gogoi, amicus, Lordship.
Mr. D. Gogoi, amicus.
Yes.
You have taken consent of Mr. B. Chetri?
D. Chetri, Lordship.
You are appealing?
On behalf of BCP.
B. Chetri. So consent is there? With the consent of the other side, the learned counsel, Mr. R. Bora.
Lordship.
R. Bora appearing on behalf of Mr. D. Gogoi, the learned amicus for the respondent number 2, wait for an adjournment. Prayer allowed. List the matter accordingly when it can be listed. After 3 weeks, list after. Is there any interim? She can tell us. Is there any interim?
It's
You
a
don't
revision
think so?
against charge sheet, Lordship, filing of charge sheet.
So I don't think there is any interim.
Yes.
Interim it is there. Okay, that's stating. Yes, interim order is there. After 3 weeks, till then, interim be continued. Instead of
Item 30.
Yes.
Yes.
My lord, here,
My lord, we have obtained instruction, my lord, in this case.
Yes.
And charge sheet has been submitted, my lord.
charge sheet here, charge sheet has been submitted today. So the petitioner was arrested on 31st. And if the lordship counts from 31st, so today is 181 days. So lordship would be pleased to call for the record, and that apart, we have taken the ground also, that affidavit also filed lordship, that non-furnishing of the grounds during the
Charge sheet
arrest.
already filed at which date, do you know? What it is?
No, my lord, as per my information, my lord, charge sheet submitted on 28th, yesterday, my lord.
Yesterday.
Yesterday, my lord.
It has come up today because I'm conducting trial also. It has come up today in the afternoon, lordship.
Yeah.
Not yet registered, even though we are considering it to be submitted, lordship. So my prayer at this stage, latest short date be fixed with the scan record, lordship. That is my prayer,
Scan
lordship.
copy of the record along with the copy of the charge sheet, my lord. That will reflect, my lord.
One copy of the case record along with the copy of the charge sheet.
Lordship,
Be called for. Yes.
7th, lordship, because otherwise you'll be entitled for default bail, lordship. So 7th may be fixed.
7th may not be
And lordship,
possible.
nothing has been recovered for
No,
this.
no, no,
petition.
7th is not possible on our part to fix the date.
Then
Let me 14th.
14th to
14th.
lordship may take up on 9th, lordship, because we'll be arguing on
Since
default
there are
bail,
fixed
lordship.
matters, most probably
9 it will
around
not be
25.
much time.
No, time is otherwise. 25 to 30 matter each day is fixed. Matters are there. So that is our problem. Time may not time
9th,
given.
lordship, 9th.
9th I cannot say. 9th 4 by 9. 14th. Bahut matters are. Okay, 14th.
14th, lordship. From the Amingao district and session judge.
Yes, okay.
Obliged, lordship.
33.
Yes, Mr. Kyle.
Lordship, in this case, I have received a copy of the
Yes, diary is.
case diary. But Lordship, I could not go through the entire materials because he appeared, and Lordship, sufficient material is there. I'll file some synopsis, Lordship, written synopsis tomorrow. Let's may take up day after tomorrow.
Day after tomorrow is not possible. First, we have some matters and one matter from Itanagar benches. There will take a long hearing. So may not be possible on first and first paribus and one. You will going to file the written thing.
Synopsis, Lordship, because sufficient materials may recovered during the investigation.
Okay.
My humble submission, Lordship, is not entitled to protection of anticipatory bail.
Okay.
Lordship after 14th time?
Lordship,
Because
it will be
in-
too long, Lordship. Because Lordship, his involvement is found in many episodes. I'll take only 5 minutes.
On 5. 5 maybe. 5. 5th of May.
Interim may be continued.
Yes, definitely. 33 corridor, heard Mr. W.R. Methi, the learned counsel for the petition, also heard Mr. Last occasion, Bernard, CGST were appearing or what, no?
CGST.
Oh, Standing Council CGS. GST, sorry, Standing Council Mr. Kyle, and Standing Council GST.
CGST.
Episode CD received. However, Mr. Kyle submitted that he will, no. Considering the submission made by Mr. Kyle, let the matter be fixed on 5/5/2025. Till then, CDB reading and interim may be extended till next date of list.
Okay.
And if a copy of the Senate is okay.
Definitely, I'll supply copy.
Yeah, that's a good way.
Mr. Medhi,
Yes.
your full name, please.
W, Ritu Raj. Ritu Raj actually.
On Ritu Raj, but why W?
W, like, it was given by my mother. There was some numerology, some.
Okay, then W, then
WRIT.
Then
Actually, it should be pronounced in a different note, but now I'm
Yes.
pronouncing in the general note. Actually, it should come
be
as
pronouncing the Ritu.
Yes,
Yes,
Ritu. It should come as Ritu.
Yes,
Yes, Ritu Raj. But normally I say it's Ritu Raj. So that's the
Anyway, WRITU.
Yes, yes.
Okay.
Applies.
Petition item 9.
Just a second, we'll finish the question. Petition hearing was.
Our third matter regarding my lord 125 DV Act proceeding. There was a maintenance in a DV Act proceeding. There was an order of payment of maintenance of ₹5,000. An appeal was preferred by the petitioner. That appeal is pending, and when admitting the appeal, the learned appellate court had passed a direction that the appeal is to be admitted subject to the petitioner paying 50% of the maintenance amount. That is, he is to keep on paying ₹2,500 per month maintenance, and the compensation component was stayed only 50% of the maintenance amount. Now, petitioner side has
In the appellate court.
by the appellate court. That is pending. So petitioner side has filed this revision petition, and now the execution of the order in the DV case as well as the entire appeal has been stayed by this honorable court.
Yes.
The revision petition of contention is that the
So
respondent
your part you have already completed or still there?
almost completed, but
Almost
they
completed.
have submitted some decision of the Honorable Supreme Court
Okay.
stating that even if because she was second wife, though, and the first marriage is still subsisting. So our main contention in the appeal is that she is not entitled to any maintenance because her marriage with the appellant is void ab initio. That was the contention.
But they belong to Muslim community or?
Muslim. Latif, they have submitted a decision.
So as per you, second wife, she is second wife, not entitled.
No, Lordship. First marriage is still subsisting, Lordship. She is the applicant here. So she can't divorce. No divorce petition is pending, and no divorce is being affected. She had married after 14 years. She married me, and during cross-examination of the proceeding, came out. I will come up the relevant portion that she had neither filed any divorce petition with her first husband, nor any petition is pending, nor she had made any effort to that effect. So our main contention in the appeal is that she is not even entitled to any maintenance from me, and they have submitted one decision of the Honorable Supreme Court stating inter alia that this is applicable in this particular case. That is N. Usarani and others, and Modula Srinivas. On the last date, they have submitted this. What I am on is that I have gone through the judgments between the lines, and my respectful submission is that this judgment is not applicable in my case, in the facts and circumstances of this case. Whereas this is a case of a single judge of the Honorable Supreme Court, wherein Lordship, they have referred and they have discussed many judgments, out of which one judgment is
K. Vimal versus K. Virasamy. That is being referred in the decision. It is 3 judge bench, Lordship. I would like to refer the relevant portion, Lordship. Page 4, second para. It is 3 judge bench of the Supreme Court, Lordship, wherein it was held there. Second para, line number 9, Lordship. Page 4. Yes, Lordship.
Yes, second para, line number 9.
Yes. However, under the law, a second wife whose marriage is void on account of the survival of the first marriage is not a legally wedded wife and is therefore not entitled to maintenance under this provision. Therefore, the law which disentitles the second wife from receiving maintenance from her husband under section 125 CRPC for the sole reason that the marriage ceremony, though performed in the customary form, lacks legal sanctity, can be applied only when the husband satisfactorily proves the subsistence of a legal and valid marriage. Lordship, in this particular case, the husband failed to prove the marriage, so it was allowed. But in our case, Lordship, only I would like to refer only 3 lines of the cross-examination part of the PW1, that is the wife. Lordship, it is page 31 of my petition. Page 31, Lordship. Vernacular evidence, cross-examination. মোৰ নুৰ ইছলামৰ লগত বিয়া হোৱা আৰু সিৰাজউদ্দিনৰ লগত বিয়া হৈছিলো আগলৈ আৰু 14 বছৰ আছিলো তাতো মোক বহুত অত্যাচাৰ কৰিছিল আৰু তাৰ পৰা গুচি আহিছো 14 years মোক অত্যাচাৰ কৰিছিল মই তালাক বিচাৰি কোনো কাজী অফিসত এপ্লিকেশন দিয়া নাই মই কোনো আদালতত ডাইভোর্স ফাইল কৰা নাই Lordship, it is the version of the respondent, opposite party, in cross-examination. And moreover, her sister, that is PW2, page 34, she has also said that Mur Bhoni, Sophia Khatun, এই কাজিমুদ্দিনৰ ল'ৰা সিৰাজউদ্দিনৰ লগত বিয়া হৈছিল ভনীয়েকে কৈছিল সিৰাজউদ্দিনৰ লগত বিয়া হৈছিল তেওঁ কৈছিল যে I got married 14 years back. So, Lordship, the decision of the case referred by my learned friend, there is no any ratio, Lordship. Ratio is this which I have referred, which the Honorable Supreme Court in a single judge has also referred. And the Honorable Supreme Court has also referred many other decisions also in the same judgment, which they have referred. They have, here is what happened, Lordship. They have also referred wherein it was allowed to the second wife, that is Rameswarandu Rampratanji Daga versus Rameswaranji Rampratanji Daga. That was in the in page 3, para 7 of the judgment they have referred. That is wherein I would like to read out the relevant lines, Lordship. The court considers that although there was no legal decree of divorce from the first husband, the wife had given customary divorce shortly, and the factum of the first marriage was not concealed from the second husband. That was the 2 conditions, that the wife had given shortly the customary divorce, and the second was this, that it was concealed from, not concealed from the first husband. This is not the case of my case. My case is clear that she got married with somebody, and during cross-examination it came out that after 14 years, she got married with me, and I have challenged on that count, Lordship. If now I have to pay the maintenance, Lordship, during pendency of the appeal, that means the legal proposition would be different, Lordship. Because if then the first marriage is subsisting now, then she has got right, if she marries third one, anybody, not she, anybody marries third one or fourth one, that she may legally entitled to file application for maintenance from the first, third, fourth, fifth. So that is not the legal proposition, Lordship. legal proposition is that if the second marriage is void ab initio, she is not entitled to maintenance. So on that count itself, we have filed the appeal. We have only filed this revision to remove to pass an order revising the condition of admitting the appeal, Lordship. If in appeal, because if in appeal, this court finds, that is another aspect, Lordship. So we are challenging the judgment in the appellate court, and appellate court admitted the appeal, but they have made a condition that I have to pay maintenance. That is the my submission, Lordship. And so far as their judgment is concerned, I have pointed out one judgment, and moreover, in every judgment, Lordship, whatever the Honorable Supreme Court has referred in a single judge bench, wherein they have referred to other judgment also. That is, Lordship, in page 13 of the judgment they have referred. That is not applicable in my case, Lordship. That is Jamuna Bhai. One case is Jamuna Bhai and the other is Bokul Bhai, wherein in page 13, Honorable Supreme Court has observed that, however, a plea of separation from the first marriage was not made in those cases, hence they are factually distinguishable. So those cases are not applicable in this particular case, Lordship, because here no case of any filing of divorce or no case of any divorce by customary rules are pleaded. Here it is a clear and clear case that my marriage is still subsisting with the first husband. That under such circumstances, I think and we pray that we are not entitled to be imposed to pay compensation, even if half, 50% or whatever it may be. We will pay 100%, Lordship, if the on conclusion of the appeal, Lordship.
Please, your Lordship. So it is submitted on the last day. But there are some differences which have come up in the submission. Learned senior colleague is appearing, and it's my fortune to be arguing against him in this case. My lord, I've learned so much from him. But on the last occasion, if your Lordship would remember, the earlier counsel who was arguing, they had very clearly said that they were assailing both orders. The order of the trial court in the DV proceeding, as well as the order of the appellate court admitting the appeal subject to payment of rupees 2,500. In fact, in the cost title also, they have impugned both orders. Now, as far as the DV case order is there now, since today my learned senior colleague is submitting that they are only confining their case to the appellate court's order, so I will not submit on that part because that order is already under examination before the appellate court. Now, whatever merits of the case they may have, those will be examined by the learned appellate court. That will be examined by the appellate court, including this plea which they have raised. I will come to the merits of the plea also, madam. But this aspect as to whether there was a subsisting marriage, whether the subsisting marriage in any way creates an encumbrance in my right to get maintenance from the petitioner, these are all aspects which will be examined by the appellate court. Now, if we are confining ourselves only to the order whereby the appellate court has imposed a condition of payment of 50% of the interim maintenance, 50% of the maintenance amount, that is a purely interlocutory order. So if it is an interlocutory order, the bar under 397 to CRPC is squarely applicable in this case. Now, this application has not been filed under 482, has not been filed under Article 227. This is an application which has been filed under 397 and 401 of the CRPC. Now, if it is a revision petition under 397 and 401 of the CRPC, then the interdict of 397(2) will be applicable. If it is an interlocutory order, it is not revisable. So their revision petition is itself not maintainable. No matter whether this is an interlocutory order or not, your Lordship is already aware of the law. It started with Amarnath's case, then Madhulimai, subsequently Girin Suneja's case. I'll just rely on the relevant portion as to, because only in case of an intermediate, final order is revisable and intermediate order is revisable. But an interlocutory order is not revisable. So whether this order is an interlocutory order or not, they will do that. I'm only relying on the latest judgment because here Madhulimai and Amarnath have already been discussed.
Yes.
Your Lordship will kindly come to para 15 of the judgment, my lord. Girish Kumar Suneja versus CBI, 2017, 14 SCC 809.
Para 15, no?
Para
Yes.
Para 15. While the text of subsection 1 of section 397 CRPC appears to confer very wide powers on the court in the exercise of its revision jurisdiction, the power is equally severely curtailed by subsection 2 thereof. There is a complete prohibition on a court exercising its revision jurisdiction in respect of interlocutory orders. Therefore, what is the nature of orders in respect of which a court can exercise its revision jurisdiction? There are three categories of orders that a court can pass: final, intermediate, and interlocutory. There is no doubt that in respect of a final order, a court can exercise its revision jurisdiction. That is in respect of a final order of acquittal or conviction. There is equally no doubt that in respect of an interlocutory order, the court cannot exercise its revision jurisdiction. As far as an intermediate order is concerned, the court can exercise its revision jurisdiction since it is not an interlocutory order. The concept of an intermediate order was first found mentioned in Amarnath versus State of Haryana, in which case the interpretation and impact of section 397(2) CRPC came up for consideration. This decision is important for two reasons. Firstly, it gives the historical reason for the enactment of section 397(2) CRPC. And secondly, considering the historical background, it gives a justification for a restrictive meaning to section 482 CRPC. As far as the historical background is concerned, it was pointed out that the Criminal Procedure Code of 1898 and the 1955 amendment gave wide powers to the High Court to interfere with orders passed in criminal cases by subordinate courts. These wide powers were restricted by the High Court, and this court, as matter of prudence and not as a matter of law, to an order that suffered from any error of law or any legal infirmity causing injustice or prejudice to the accused, or was manifestly foolish or perverse. This led to courts being flooded with cases challenging all kinds of orders and thereby delaying prosecution of a case to the detriment of an accused person. I might well skip the next two paragraphs. Paragraph 21, Your Lordship will come. Paragraph 21. The concept of an intermediate order was further elucidated in Madhulimai versus State of Maharashtra by contradistinguishing a final order and an interlocutory order. This decision lays down the principle that an intermediate order is one which is interlocutory in nature, but when reversed, it has the effect of terminating the proceedings and thereby resulting in a final order. Two such immediate orders immediately come to mind: an order taking cognizance of an offense and summoning an accused, and an order of framing charges. Prima facie, these orders are interlocutory in nature, but when an order taking cognizance and summoning an accused is reversed, it has the effect of terminating the proceedings against that person, resulting in a final order in his or her favor. Similarly, an order for framing of charges, if reversed, has the effect of discharging the accused and resulting in a final order in his or her favor. Therefore, an intermediate order is one which, if passed in a certain way, the proceedings would terminate, but if passed in another way, the proceedings would continue. So, my lord, what is an intermediate order? An intermediate order, as the Honorable Supreme Court has clarified, if it is passed in any other way, then the proceedings would get terminated. Cognizance order, discharge order. That is why a separate class of orders was created by the Honorable Supreme Court, intermediate orders, which were allowed to be revisable. If this is an order, suppose this 50% component was not there. That plea had been that part had not been directed by the appellate court. Proceedings would not have terminated. This is purely an interlocutory order. So if it is an interlocutory order, this order is not revisable. They can ventilate all of their grievances before the appellate court. Nobody is stopping them. There is no encumbrance. But to ask this honorable court to give a finding on this aspect, this will directly have an impact on the appeal. Let the appeal be decided on its merit. They have only been asked to pay 50%. And now, what my learned senior friend has submitted regarding the judgment of K. Vimal versus K. Viraswamy. That is in the context of 125. I will also produce other judgments, my lord, on this aspect. That is in the case of 125 CRPC.
This is the same, Lord.
This is a DV case, my lord.
DV maintenance proceeding is out of 125. You go to section 20. Section 20 is that in or under 125. The proceeding,
I'll submit, then he can revert me, my lord.
that's I'm pointing out the
20.
section 20.
20.
It is even if it is DB, it is under 125. Lordship.
Section, what section 20 says that? What section 20 only says that maintenance on every person as well as children, if any, including an order under or in addition to an order of maintenance under section 125. So if there is an order under 120, your lordship knows the law on this. I don't have to clarify this. It only means that a 125 proceeding and a DB proceeding can simultaneously occur. I'll also show the judgments where this distinction is drawn. The judgment which my learned senior friend has relied upon is squarely in a case of 125 CRPC proceeding. 125 CRPC categorically uses the word legally wedded right. Now, in case of DB, your lordship will, if your lordship has the DB Act number. Lordship will kindly come to section 2F.
Yes.
2F, madam, describes what is a domestic relationship. Unlike 125 CRPC, 2F says domestic relationship means a relationship between two persons who live or have at any point of time lived together in a shared household when they are related by consanguinity, marriage, or through a relationship in the nature of marriage. So there is specific distinction between marriage. There are two categories. Apart from any other categories, even in the nature of conjugal relationship, there are two categories. One is a relationship in the nature of marriage, and one is marriage. So suppose if we assume what my learned senior friend is submitting, that is true, it is still covered by 2F. There is a relationship in the nature of marriage. Now, coming to the facts of the case, why even this distinction is irrelevant, your lordship will kindly come to the judgment. Page 16. Relevant portion, page 18. Line 1, 2, 3, 4, 5, 6, 7. 8th line, my lord. In the written statement.
From whose judgment you're saying?
No, not from the petition, madam. Criminal petition.
Oh, criminal petition page?
Page 18, my lord.
Yes.
Page 18, madam. 8th line. What you will find in the written statement.
Yes.
In the written statement submitted on 19/4/2019, the respondent denied all the allegations and pleaded that the aggrieved person is his second wife. So the respondent also admits this part, that the respondent is his second wife. That part is admitted. Next, the first wife of the respondent died, leaving behind her 4 children, but the children never found any love and affection from the aggrieved person. Instead, she misbehaved with them. During her stay in the respondent's house, she tried to avoid the respondent and visited her brother-in-law's house several times without the consent of the respondent. So marriage is admitted, cohabitation is also admitted. Now my lord will come to the next page, page 19. Just before point for determination. The aggrieved person got married to one Muhammad Sirajuddin prior to her marriage with the respondent. So the petitioner was well aware of this fact that she was married to Sirajuddin, because this WS was filed even before her cross-examination. So this is also not a case where this earlier marriage with Sirajuddin was concealed by the aggrieved or the respondent in this case. Factum of earlier marriage disclosed. Petitioner admitted marriage with the aggrieved. Petitioner also admitted that they cohabited together. Now coming to the evidence, which my learned senior friend has relied upon.
No. This way he came to know subsequently that she got married with another person. So, considering her first marriage.
What I am submitting is that, they have treated this in the written statement.
Yes.
Before their cross-examination. Now, we do not know when they found out. The only thing which we know from the record is that he was aware. Now, when he came to know, he has not adduced any evidence to that effect, that I did not know earlier, I came to know later. He has only pleaded that she was earlier married to Sirajuddin. Now, it is for them to plead when they have come to know that I have concealed the earlier marriage. Even in her cross-examination, what does the aggrieved say? Page 29. I have not filed any application before any Qazi office in order to obtain talaq, nor have I filed any divorce suit. We had a compromise in court through understanding. I wanted to file a case, but I was not allowed to file by my guardian after consulting an advocate. Now, is my learned senior friend trying to say that this is the only mode of getting a divorce for a Muslim wife? There are multiple modes. Khula is there. If the both parties have gone and made an agreement, whether their marriage still subsists. Now, in the judgment which they have relied upon, I will cite their judgment itself to counter this point. Vimala versus Veeraswamy. The lordship has the judgment. May I read my?
Just a second. Yes, what you know?
There are 3 men.
Oh, Vimala.
Vimala, my lord. Their judgment I am relying.
Vimala.
The judgment which was cited by my.
Oh, sorry, yes.
Vimal versus Kev.
Yes.
Sorry, Vimal versus Veeraswamy. Para 3.
Para 3.
I have the SSC one, my lord. Paras may not meet. Section 125 of the Code of Criminal Procedure.
You're in your case, para 3.
Section 125 of the Code of Criminal Procedure.
Yes.
Of the criminal procedure is meant to achieve a social purpose. The object is to prevent vagrancy and destitution. It provides a speedy remedy for the supply of food, clothing, and shelter to the deserted wife. When an attempt is made by the husband to negative the claim of the neglected wife, depicting her as a kept mistress on the specious plea that he was already married, the court would insist on strict proof of earlier marriage. The term wife in section 125 of the Code of Criminal Procedure includes a woman who has been divorced by a husband or who has obtained a divorce from her husband and has not remarried. The woman, this part they are stressing, the woman not having the legal status of a wife is thus brought within the inclusive definition of the term wife, consistent with the objective. However, under the law, a second wife whose marriage is void on account of the survival of the first marriage is not a legally wedded wife and is therefore not entitled to maintenance under this provision. This is what they are citing. Now, the next part. Therefore, the law which disentitles the second wife from receiving maintenance from her husband under section 125 CRPC for the sole reason that the marriage ceremony performed to the customary form lacks legal sanctity can be applied only when the husband satisfactorily proves the subsistence of a legal and valid marriage, particularly when the provision in the code is a measure of social justice intended to protect women and children. We are unable to find that the respondent herein has discharged the heavy burden by tendering strict proof of the fact in issue. The High Court failed to consider the standard of proof required and has proceeded on no evidence whatsoever in determining the question against the appellant. We are therefore unable to agree that the appellant is not entitled to maintenance. So this
in that particular case, husband has failed to prove the marriage. Here, the wife has specifically stated in her cross-examination that I got married 14 years back, so and so, so and so. So I am not required to prove lordship. That is the difference. Here in the Supreme Court, why allowed? Ultimately saying all these things, why allowed? Husband has failed to strictly prove the same. Here we are not required to prove lordship. That my contention is there.
Here, what the Honorable Supreme Court has said that strict proof, heavy burden. And what is the burden which they have? How the burden?
burden.
Kindly let me submit. Now, how is the burden discharged? By relying on these facts in cross-examination. What do they prove? As I have submitted, my lord, Muslim marriage can be dissolved in multiple ways. Talaq is there, Ila is there, Zihar is there. Multiple modes are there along with dissolution by a judicial decree. So just because I have not obtained a decree of divorce from a competent court, does it mean that the marriage is still subsisting? When strict burden is cast upon them, why were they sleeping? They could have easily examined evidence to show this. They have to discharge the strict burden. This does not in any way prove that marriage is still subsisting. It only shows that at one point of time I was married.
subsistence of that marriage has to be proven by them. That has not been proven. This is the context of what they have cited. Now, this judgment is a 1991 judgment. It has been time and again examined and reiterated in different judgments. Now your lordship will come.
Sir Nawaz, I can give you only 5 minutes. Most probably it will maybe fix tomorrow. 5 minutes I'm hearing. From 3 actually.
My lord, I understand that.
So
I'll
5
try to wrap
minutes,
up. Otherwise, my lord, we keep it.
tomorrow may be fixed. You have for 5 minutes you
My
can.
lord.
have. Then it will be because again it will be remain as a part of it. So tomorrow we'll try. Tomorrow we can try to fix the matter. Otherwise, for 5 minutes you can argue. Yes. So it is submitted by you. This also.
Chalmunia, yes, my lord. Chalmunia. Paragraph, my lord, 23. Paragraph 23 of Chalmunia, my lord. This Vimala versus Veeraswamy is discussed. And subsequently, my lord, will kindly come to para 35. We think, because in Chalmunia, a reference was made to a larger bench on this issue as to what happens if the wife is not a legally married wife. Now, 35, what does the Supreme Court say? We think that the larger bench may consider also the provisions of the Protection of Women from Domestic Violence Act 2005. This act assigns a very broad and expansive definition to the term domestic abuse to include within its purview even economic abuse. Economic abuse, so that part I'm my lord, I'm omitting. Then, my lord, para 41. This is the reference which has been made by Chalmunia. Number 2, whether strict proof of marriage is essential for a claim of maintenance under section 125 CRPC, having regard to the provisions of the Domestic Violence Act. So I have just, my lord, summarizing it. Here also, Honorable Supreme Court made a distinction between 125 CRPC and DV Act. And since this was an issue which was referred to a larger bench, that whether strict proof of marriage is required or not, Supreme Court said that DV Act gives a very wider definition to a domestic relationship. So the considerations of the domestic violence may be considered by the larger bench while deciding this issue, my lord. So distinction between the definition of a wife or domestic relationship in case of a DV Act has been made by Chalmunia. Another case, D. Velaswamy, I'm just, my lord, just hurrying, my lord. Here also very specifically, Vimala, after discussing Vimala Veeraswamy, the Honorable Supreme Court says that in DV case, that law is totally different, my lord, because the DV case does not necessarily depend on proof of marriage. Any relationship, whether if it's in the nature of marriage, then also maintenance can be granted. That is what says even in live-in relationships, where there is no marriage, in those cases also, my lord, maintenance can be granted. So these are, and on the last occasion, my lord, I have already cited their judgments, so I will not repeat their judgments, Usha Rani's judgment, my lord, where again, Vimala, all of these issues have been discussed, and there's what my learned senior submitted was only a portion of the judgment. There was a specific issue which was framed in Usha Rani on same facts, my lord, whether if there is a subsisting marriage, in that case, whether the second wife will be legally entitled to marriage or not.
That has not been answered.
It has been answered, my lord. It has been answered. It has been answered. I read the last part, my lord. In any case, all of these judgments are on the context of 125 CRPC. DV Act stands on a totally different footing. 125 analogy cannot be brought in DV Act. And all of these issues, my lord, will eventually be examined by the appellate court. Again, I come back to the fact that this being an interlocutory order is not revisable. Even if an endeavor is made to project it as not as an interlocutory order, even because of these facts and these evidences, this law, my lord, this petition is liable to be dismissed. This
Lordship, my reply is that this is not an interlocutory order. So far as the paying maintenance is concerned, this is final in respect of curtailing my rights, Lordship. I have not been asked to show cause as to why this maintenance will be passed or order will be passed or not. The court has already passed an order curtailing my rights. This is not an interlocutory order, Lordship. This is not an interlocutory order, my learned friend, trying to interpret the intermediate order and mix up this order as an interlocutory order. So this is a revisionable order, Lordship. We only prayed for this revising the condition of the admission order, Lordship. That is the.
Any finding your lordship will give will directly.
And lordship, although the domestic violence matter is defined to that of 125, lordship, here in this case, it is not that we are praying for living relationship. We have said that I am wife. So in that context, that is admitted question. That is admitted question. So 125, the spirit of 125 will come into play. All the judgment they have also referred, that was of 125 lordship. The judgment which they have referred, that was of 125. And all the three bench double bench judgment which was referred in the single judge bench of the Supreme Court, lordship, that was all most of the judgments was of 125 lordship. The spirit is same, lordship. That is the condition.
Spirit is same otherwise, but what Mr. Nawaz is most probably interpreting from the definition of 2F. It's
Yes.
rather in a
If I claim, lordship, if I claim that I'm not wife, just I am living with him, then his submission, the interpretation of section 2F would have come into play. I'm saying that he is my wife. He is my wife. They are also not denying that I am her husband. So in that case, husband and wife, in that case, the spirit of 125 will come, because the maintenance order in respect of 125 or in or under, that may come, lordship. Lordship will certainly appreciate. But my point is that the law, this is not the ratio that the second wife is entitled to maintenance during subsistence of the first marriage. This is the ratio, lordship. The other thing is that under facts and circumstances, some particular case, the Supreme Court may allow, but in the judgment which they have referred, there are lots of cases. I have read between the lines, lordship, in the DB judgment and in judgment passed by three judgments. It is the law that the second wife is not entitled to maintenance if first. So that matter, certainly the evidence will be appreciated in the appellate court, lordship. We only require the removal of the condition now. That is that.
Not take much time, just one point. We never pleaded legal relationship. That is, I am only submitting in this context. It is said that we are submitting a marriage. They are saying that it may not be a marriage because subsistence. It would still be in the relationship in the nature of marriage in terms of 2F. And 125 and PV with totally different footing cannot be used. So, my lord, the lordship will not interfere with this order.
My lord, in item number 35, I am appearing for the respondent number 2. Item number 35, my lords. I am appearing for respondent number 2, State of West Bengal.
Yes, Mr. Deb, it was in the morning hours, it was intimated by my courtmaster that one request is there for item number 35 for a hearing through VC. But I'm very sorry to say we don't have time. In fact, I have a division bench at 3. So it has to be adjourned today.
So my lord will kindly fix a date. Will it be possible day after tomorrow, Thursday?
Day after tomorrow.
Will it be possible for your lordship?
It will be in the month of May. We'll try to accommodate you. I don't know.
On 15th of May? On 15th of May, my lord, I will come. I will personally come to argue the matter.
Will you be able to come on 28th personally? 20?
20, my lord, I am traveling.
Of May?
I have some personal problems. Will it be possible? On 15th of May, I can come down on 14th. And I can argue the matter on 15th. 15th is a Thursday. If my lord can kindly accommodate me.
Okay, we'll try, because there are some matters have already been fixed on from Itanagar bench also. So if you are personally coming on 14th, then we'll try to accommodate you on 15th.
I will come. I will come.
Okay. Okay.
I will come.
Okay.
My lord will kindly fix it up.
Okay.
My lord will kindly fix it up on 15th.
Okay, 15th. Okay.
Lordship, in this
I am deeply obliged.
appealing for respondent number 1, Lordship. In this matter, I am appealing for respondent number 1, Lordship. We'll file our affidavit, Lordship.
By the time you can file your affidavit, and up to 15th?
15th.
15th. We are fixing it on 15th. You can file your affidavit also.
We'll try, Lordship. We'll try.
In the meantime, I will also file my affidavit on behalf of the state of West Bengal, respondent number 2.
Okay then, okay. Sure.
There is an interim order. Interim may be extended.
Interim was there?
Yes.
Okay then, interim be extended till next date of listing. In the meantime, if you want to file you also, if you want to file any affidavit, that can be filed within 15th. And the other side also, they are interested to file the affidavit. So within 15, we are allowing it. Till 15th.
My lord, I did not voting may be taken after 2 weeks.
Okay, rest, I have.
It may be recorded, my lord.
Okay.
In the order sheet.
Item number 15. It will be fixed on 15th. We are fixing it on 15th.
15. It may be recorded in the order sheet, my lord.
Oh. Yes, definitely. It will be reflected in the order sheet only. Yes.
I am deeply obliged.